Here, welcome. I'm Ada Kay,
your deaf courtroom commentator, breaking down the gripping courtroom drama, providing ASL interpretation when possible, while making justice accessible to everyone. Grab your favorite cup of Java and let's dive in.
Good morning, everybody, and welcome to day 5 of the Wolfenbarger trial. Christopher Wolfenbarger is on trial for the red drum of his wife. It is a cold case trial. Let me do a really quick rundown so everybody is on the same page. I know that we may have some new people in here who really don't know what this trial is about. So let me do that before we actually get into the trial. We are waiting for court to begin. But first, I want to welcome first in chat, Erin. Erin, I sent you a thing in Discord. All of your emails with I have all 3 of your hats ready to start working on. But guess what, boo? For some reason, they're hidden. So just send me a quick email that says, hey, it's me. And that way they'll pop back up. Okay? Because I am working on your hat. Lady Jane, 2nd in chat. June, 3rd in chat. One sunny day. Thank you guys all so much for hopping on. So let's go through the Wolfenbarger's lowdown. I took the stairs and I'm here. Woohoo! Okay, so this is day 1. The prosecution alleged Christopher was abusive, controlling, and disposed of Melissa's remains near his workplace, highlighting that the saw marks on the bones were done post disappearance behavior. The defense claimed that Melissa fled an abusive family, pointed to alternative suspects, including her parents, and emphasized the lack of forensic evidence. Her father was convicted of being a serial red drummer, and her mother turned state witness, and she helped him remove the remains. Hi, Cece! Thank you so much for joining. George, the witnesses on day 1 was George McAkron, found Melissa's skull on Avon Avenue in 1999, moved it with the stick, and called 911. Detective Dale Kelly, lead investigator, admitted the VHS tape showing a dog dragging the skull in a bag is missing along with its report. Detective Tina Miller found an additional remains on June of 1999 behind an auto shop. Described the decomposition, thank you, and the scene in detail. Day 2, which was the 17th, the defense cross-examined Blitz Ronald Brock, Action Glass owner, claimed that Christopher borrowed a reciprocating saw. Is that how you say it? I may be wrong. Or a saw. Under cross admitted falsely termination records, and that saw were common on the job site. So he falsified the termination records. The job was normally on site. Cynthia Brock, the manager, couldn't confirm the saw borrowing firsthand, but contradicted herself about whether it was returned. Dorothy Coley, the neighbor, claimed the witness abuse and the arguments cross revealed 11 arrests, memory gaps, and inability to confirm which unit arguments were coming from. So The defense dismantled credibility of all three witnesses under 90 minutes of shifting narrative towards the prosecutorial desperation. Day 3, Norma Patton, Melissa's mother, testified that Melissa was repeatedly abused by Christopher, including being dragged along pavement in 1998, admitted to helping her husband, Carl Patton, dispose of bodies in the 70s, and granted immunity for exchange for her testimony. The defense, hello, Angela. Hello, CC. The defense painted Norma as a potential suspect with the motive to deflect the blame and to protect her husband. Parole prospects. Day 4, the forensic analyst confirmed the saw marks on the bones could not link the tool to Christopher. Cold case detective admitted delay and missing files in the chain of custody. Christopher's daughter recalled alleged incriminating statements, exposed confusion about the dates and the content. Thank you so much for sharing. The defense behavioral psychologist suggested Melissa may have been fleeing multiple abusers, not just Christopher. So that is where we are on the road thus far. Let me get this on stage. I thought I had it already, but I didn't. My apologies. There we go. I'm going to delete this. So we are sitting here and waiting for this to start. While we're waiting, we have my previous live that I just hopped from one to the next. We were rewatching the testimony of Wendy Adelson. I'd like to continue that. We've got probably about 15 minutes left of that particular one, and then we'll watch another one. But I have a note. Final note. Donna's mother, Ruth Markle, was in the Donna Adelson case. Donna's mother, Ruth Markle, has written a book. I'm sorry, not Don. Dan Markle's mother, Ruth Markle, has written a book that is just out. The Unveiling, a Mother's Reflections on Murder, Grief, and Trial. I got to see who's walking in the door. It's my son. Talking about a mother's grief and trial life. Earlier this year, Ruth saw her grandchildren for the first time in about 10 years. Florida law formally gave no rights to grandparents to visit their grandkids. A new Florida law, this is new, I didn't know about this, called the Merkel Act, yay, passed in 2022, gave grandparents visitation rights in narrow tragic situations. So there's limited grandparents' rights called the Merkel Law. So congratulations for getting that passed. It did not work. Well, my apologies. Maybe I didn't have it set up long enough. I apologize for that. Sometimes they are glitchy. So I'd like to go ahead and share this. We're going to keep listening to. I've got this trial set up over here so I can keep an eye on it. Go ahead and listen to the Wendy Adelson's testimony as it continues in her brother's case.
About your parents not liking Tallahassee and not having access to the kids in Tallahassee. Do you recall those questions?
I don't remember her asking whether my parents didn't like Tallahassee, but I remember her asking about access, like not having unfettered access to the kids.
And do you remember talking about how your parents were looking for real estate in Tallahassee?
Yeah, my parents were trying to buy a house here.
Do you recall that after you got divorced, they contacted a real estate agent named Tim Kelly to buy that house?
Yes.
During the course of your marriage, I think you said you were close to your brother, Charlie.
Yes.
How often did you speak to each other?
Maybe once a week or a couple times here and there.
Now, in all the years you lived in Tallahassee, is it fair to say that Charlie only came up 2 or 3 times?
Yeah, he came up for the birth of both boys, so definitely twice. And then I think he had an internship or a job in Alabama for a little while, so he came by then, but so maybe 3 times.
Now, you described that there came a time when you and Professor Markell started to have some marital issues.
That's right.
And some of these issues had to do with religion, correct?
Yes.
And some of them had to do with just the fact that you two were growing apart. Is that fair to say?
Yes.
But you got marriage counseling, right?
We did.
How long were you in marriage counseling for?
I think about 6 months, maybe.
Now, as close as you are with your mom, While in marriage counseling, did you tell her you were in marriage counseling?
I don't remember telling her I was in marriage counseling.
And until the end, did Charlie know that you were in marriage counseling?
I don't know if I talked to my family about being in counseling.
Do you recall a time when you and Charlie, you were down in South Florida and you told him that you were having marital problems?
I do.
And what was Charlie's reaction to that?
I mean, he was supportive of me. I remember him saying, you know, life is short. So if you're unhappy, then, you know, you can make a different choice.
Do you recall a dinner at the Melting Pot where you told Charlie that you had decided to file for divorce?
I do.
And when you told Charlie that you were going to file for divorce, did he have anger and hatred towards Professor Markell?
No.
Was he sad because he knew that this was going to affect his nephews?
I don't think he was really sad. I mean, honestly, I think a lot of people wondered why I got married to Danny in the first place. And my friends were very supportive when I decided to end the marriage.
Now, you actually filed for divorce in September of 2012. Is that right?
That sounds right.
And when you filed for divorce, let me say this. When you left the home, I think that was discussed in the direct, Professor Markell was out of town, right?
He was. I called him and let him know that I had filed.
You're a non-confrontational person, right?
It is not my best quality, yes.
But you had been in marriage counseling for quite some time before you left the home, right?
Yes.
Before you left the home, did you have a place to live?
I did.
So there was some planning, correct?
Yes.
Now, Charlie had nothing to do with those arrangements, right?
No.
And that's when you moved into the Aqua Ridge house?
Yes.
I am sorry, I'm going to have to stop this. There seems to be some communications going on in this trail. They were talking. Well, that is interesting. Okay, we'll go back over here until I see more. You know what's really cold was doing it by text. At least she verbally told him.
I'm showing you what's marked as Defense Exhibit 1 for identification purposes only. May I approach your honor?
Okay.
Do you recognize the email addresses on this document?
I do.
Is that your email address in July of 2012?
It was my work email address, so that makes sense. That must have been my email.
Does this look like an email that you could have received from your mom?
It does. I don't remember this email, but it does look like an email I could have received.
Judge, I would move this into evidence as Defense Exhibit 1 at this time.
There are objections.
Objection, hearsay.
This is an email between your mom and you in July of 2012, right?
Yes.
And just pointing to just under paragraph 2, I just need to know that I can legally take my children and move to another location. There was concern that you wanted to make sure that you weren't breaking the law, right?
Correct.
What can I legally remove from the house to the new location? There was concern that you wanted to do everything within the law, right?
Correct.
Now, we've heard a lot about this TV already, so let's just clear this up right now. Charlie bought you the TV, right?
Yes.
More precisely, Charlie had your parents buy the TV and he paid them back.
Yes.
And they bought the TV from Best Buy, right?
Yes.
Have you ever bought anything from Best Buy?
I'm sure I have.
When you buy from Best Buy, they always try you to get the Geek Squad warranty, right?
Yeah, they do.
And people like me always fall for that, right? But when you call and you need a repair on the TV, it's got to be registered to your name, right?
I think so.
Do you know if the Geek Squad was registered to your mom and dad?
I don't know offhand, but if they're the ones who bought the TV, then they probably bought the, Geek Squad policy that went with it too.
If I showed you the receipt, would that refresh your recollection?
I don't really have an independent recollection, so I don't think so.
We'll come back to that. Now, Charlie made that joke many times, right?
He did.
He never told you he actually looked into hiring a hitman, right?
No.
Did you think he was serious?
No,
By the way, the state has you as a co-conspirator with Charlie Adelson, right?
I believe so.
But they also have you, according to them, blurting out during an interview that your alleged co-conspirator did the murder. Does that make any sense?
I don't understand the
Let me
question.
rephrase. They have you guys as co-conspirators. They think you did a murder together, right?
I think so. That's what they believe.
If you did a murder together, why would you have blurted out a statement like that?
I clearly would not.
Sorry.
Do you know if Charlie repeated that joke in March of 2014 when you went to Yardbirds with Jeff Lacoste?
He may have, if I was mentioning the TV was broken or something like that.
Do you know who else was at that dinner?
Katie.
During your divorce, you spoke to your mom daily, probably, right?
I would usually call my parents on my way to drop kids at school. We'd have a short conversation. So that sounds right.
And it's fair to say that your parents were involved in some of the decisions that you were making in the divorce. You were asking their advice.
For some of the time.
Did you often speak with Charlie about what was happening in the divorce?
Not too much, no.
But fair to say Charlie was supportive of you, right?
Yeah, I mean, he was always supportive of me.
Is Charlie kind of self-centered?
I don't think so.
At the time of your divorce, though, he had a lot going on in his life.
I mean, his life was going great. He had a great business. He always had lots of girls. He had friends.
The divorce was settled in July of 2013.
Correct.
How did you feel after it was settled?
I felt better. I felt a sense of relief that we could just move on with our lives.
Now, I want to talk a little bit about this relocation issue. Isn't it true that your attorney told you that there was very little chance for you to win that motion?
I believe so, yes.
Where were you working in Tallahassee?
Some are saying that the TV situation is more about codes concerning the Red Room. It wasn't really about buying a TV. Some people think that the TV was really broken and they just replaced it. Others believe that the TV was also basically code words about the Red Room.
Let's go backwards, actually. In 2007, when you were married, where were you working in Tallahassee?
At that time, I would have been working at the FSU Center for Human Rights.
And you were lobbying for anti-human trafficking legislation?
I was primarily representing victims of human trafficking, but I did a little bit of lobbying too.
But the funding for your job ran out and you lost your job, right?
Yep.
At the time of the divorce, you had gotten a job at FSU. What was that job?
At the time of the divorce, I was adjunct teaching a few classes at the law school, and I had a number of different jobs at FSU, but by that point, I was probably running something called a medical legal partnership, where I would work with the law school, the medical school, and the social work school to help the students work together to try to help solve legal problems that clients had.
Did you like that job?
They did, yeah.
So if you liked the job so much, why were you looking to relocate?
I mean, relocation was not a big issue for me. I probably never would have thought of it. A friend suggested it to me that it might be helpful. Maybe I would get more time with the kids if I could relocate. But I wasn't really focused on it. I didn't think it would happen, and I was pretty happy being at my job.
Now, you were a non-tenured clinical professor in that job, right?
That's right.
It meant that you could lose the job at any time. Is that fair to say?
Mm-hmm.
And you had a lot of responsibilities, now being divorced, even more responsibilities with the kids.
Sure.
And you were offered a job at a prestigious law firm in Miami. Is that fair to say?
I was, yes.
And that job was going to have a pretty big salary increase.
Yes.
And it was going to give you an opportunity for more stability. Fair enough?
Yeah.
You were also going to have the benefit of family
Sure.
in South Florida who could help you with the kids, right?
Yeah.
Now, even with this relocation request, was it ever your intention for Professor Markell to be absent from your boy's life?
Never, no.
Okay. When you lost the relocation motion, I think it's fair to say that your mom and dad were pretty upset.
That's right.
It's fair to say that your mom came up with some crazy ideas.
Totally bonkers, yes.
We saw the email about conversion of the kids, right?
Yes.
By the way, did you ever do any of that?
No.
So you never dressed the kids up, you never baptized them, you never took a picture of them?
No.
Okay. Did your mom keep bugging you to do any of that stuff?
No, I think it was just one crazy email.
By the way, in all of these emails, did your mom ever tell you to do something violent
No.
to Professor Markell?
No.
Was there ever any discussion of threats of violence in any way?
No, never.
Mr. Rashbaum, I'm going to let you to ask one more question, and from there, we're going to go into recess for the evening, but your examination of the witness will go into tomorrow.
Have you ever heard of the Pross blog?
Sure.
Remember those questions that Ms. Kappelman asked you about how people could know about Danny traveling on the weekend of his murder? Remember those questions?
I do, yes.
Would it surprise? What is the Pross blog?
It was a blog that Danny started with some friends to talk about the law and legal theories and to kind of have conversations in space with other law professors.
I'm showing you it's marked as Defense Exhibit 2. And this will be quick, Your Honor. I
I
promise.
was going to say, it went from 1 to 5 real quick.
It'll be quick.
Please show your exhibit to the witness.
Does this look like a posting from the Pross blog?
It does, yes.
Judge, I admit Defense Exhibit 2 into evidence at this point in time.
Any objections to the state?
I'd like to take a look at it first, Mark.
Okay, go.
Objection, hearsay, Your Honor.
I'll ask it one last question, and then we can, if you would, we can go.
One means one, not
One means one. Do you know if Professor Markell would frequently post his travel schedule on his Pross blog?
He would post it on his props blog and on his Facebook.
That's my one question.
The long list of plans that you went over with Mr. Rashbaum that you were going to have in Tallahassee post-murder date, none of those plans happened, right?
No,
Because you moved to South Florida, right?
because I felt unsafe to stay here, yes.
And did you feel safe in South Florida?
No,
Did you buy a house in Tallahassee after the murder?
no, I did not.
Did you rent a house in Tallahassee after the murder?
No, I didn't live in Tallahassee after the murder.
Did the boys go to school that fall here in Tallahassee?
No, all our plans were broken.
And what was the purpose of those questions? Of course you didn't. You moved to South Florida. You didn't have plans in Tallahassee. They got executed.
June, is this from you? Oh my God. I've always wanted one of the screaming pickle. Oh, we got the pickle. Uh-oh. Won't shut off. OMG. Okay, I suspect this was June. OMG. But if it wasn't, whoever sent me this is awesome. Thank you so much. And if you don't understand what this pickle is about, you need to go back and watch yesterday's live. We got a problem.
In the trial of the state of Georgia versus Christopher Wolfenbarger, case number 24SC004201. I'll note for the record that Mr. Wolfenbarger is present here in the courtroom along with his counsel, and that counsel for the state is also present. Mr. Samuel.
When I left court yesterday,
Y'all remember the classic pickle pose? Oh, my. It's all about the pickle, about the pickle, about the pickle. Okay, we'll throw the pickle up. We got two things going on at once. So we had the Donna Adelson. They are bringing people into trial, but this is a court case we're following. So let's keep going here, and then we'll hop over there.
The prosecutors are still in here. I was walking past, towards the elevator, and one of the jurors was in the sitting area.
Yeah.
Yes, sir.
And he looked like he was, like really, really ill. He was just kind of hunched over, and I have no medical training.
Why is there echo?
Plus, I was debating my role as a good Samaritan, and my job as a lawyer. Fortunately, I
That's on their end.
saw there was a deputy at the end of the hall.
Yes,
And I went to the deputy and I said, someone's got to do, I can't talk to this person. So the deputy went back and talked to him. I was not within hearing distance and stayed out of sight. I gather he was in great deal of pain from a back injury and was taking medication. I'm not quite sure what happened after that. I mean, the deputy eventually left. And I didn't, there was nothing for me to do. I stayed out of sight. I gather he was in great deal of pain from a back injury and was taking medication. I'm not quite sure what happened after that. I mean, the deputy eventually left. And I didn't, there was nothing for me to do. I mean, I wasn't going to sit there with the juror.
Look at his hair.
I just bring it to your attention that the juror was apparently in so much pain he was taking medication. That concerns me if if he's sitting here in the courtroom.
Well, thank you. Do you know which juror it was by number?
Certainly not by number. It was a black man, not the one who does dialysis,
So not 43.
and not the taller man who. I'm sorry, I don't.
Okay. I mean, the main reason I ask is that I'm surprised that you would have such an encounter and that juror or other jurors would not have communicated to my staff, hey, I'm having an issue. And I've not heard any such communication from that juror. So if they are struggling with that, it's unfortunate, but it seems as if they don't feel the need to bring it to my attention.
I just felt the need for me to bring it to your attention, but
I understand.
I remember, obviously I see the jury. I've never seen him in the jury box appear under any distress. So,
Okay. Well, what I'll do for now, rather than, formally inquire or put anybody on the spot, is just, if it's okay with y'all, is just have Miss Johnson check in. She's my JA who takes care of the jurors, and make sure everybody's comfortable. And if you're not comfortable, you're having issues paying attention, you need to let me know so I can bring it to the judge's attention and let you know if I get any report from that. Okay.
I'll just make a mental note of where he's sitting.
And then maybe you can tell me, we can identify him further so we'll at least know which juror it is. Okay.
I think you're right. I think because Mr. McDermott brought that to my attention.
Mhm.
And as I was going out of the courtroom, I saw that juror. I believe it's a juror who may work for Delta, if I'm not mistaken, the shorter black man. I think yesterday he was sitting in the second
or third from the end.
on the back row. I think he had on green yesterday. And I saw him leaving as I was going towards the right, towards the restroom. It looked like he was getting up from that area and leaving the courthouse.
Hang on just 1 second.
Didn't mention back work on disability.
That is interesting. But what concerns me is, why is that attorney? I know he's fighting for his client, but that to me is a little bit underhanded in a way. I don't know. I don't like it. I don't like it at all. I don't like it at all. But I'm loving this attorney's hair. It is so silky. It looks baby fine, baby soft, smooth, unlike mine.
Yes. Are we ready to get started? Wait, Miss Hilton, you said you wanted to check the audio.
How is the
Will
sound
you hit
and
play
audio?
for just a moment?
There we go. I boosted it. How's the sound? Okay. I need you guys to help me with the sound. It's going to be odd in this courtroom. I'm going to have to be lowering myself. I just lowered myself. I raised them up. So June, Mods, give me a thumbs up. It sounds good. Thumbs down if it's not. Ooh, that's on them. That's all on them. Let's talk about sound, and then that happens. Oh my gosh. Yeah, I agree. That was kind of like, dude, if he was struggling, and so what? If he thinks he can sit through court and, hey guys, there are days I can sit here and I look perfectly fine, and then I go home and I'm going, oy vey, my back. That's life. That's not a reason to dismiss the juror. If the juror can handle his uncomfortableness while he's sitting in that chair and he chooses to not say anything, then that's on the juror. But I don't know what's going on with their sound. We may have some issues. Just so you know, we do have the seal. They have just a minute ago had everybody come in. And she's in purple today.
That's fine. Response that you have one. Okay. Right, we'll come back at 1:45. I believe that you give an adequate time to have a break from there. I think as the jurors get rounded up downstairs, we'll go ahead and finish out the process as we described.
Okay, it's their lunchtime. No problem. We'll get back over here. Their sound is off on their end, not my end. I think they're trying to fix the audio.
Terry was here yesterday when we concluded. She is currently on the stand in Gwinnett. She took the stand at 11:30, and it's on now. So we're waiting for her to get out. But that would be one of our last witnesses. I think we read 3 remaining.
Forgive me, Dr. Terry is the ME? Okay.
Device not found. Ready to pair.
Oh, gorgeous hair, dude.
40039F10.
Yeah, it's connected.
The mics are horrible. I will do my best, but man.
Later on, there's someone goes in there that fight and got there. You had to work in his fault life up there on Yorville. And you had a guy that could have was there.
I think we're, okay. So are we ready for the jury? Ms. Hilton?
Yes.
Mr. McDermott?
Yes, ma'am.
Okay, can we have the jury, please?
Okay, hold on. My hands are braiding. Oh. Okay, I hear you. Give me a minute. My hands are caught in a braid, and as soon as they come back, I'll get it up. Give me a second. Oh. My hair is very frizzy today. Makes it harder to braid. My hair fingers are getting stuck in it.
I'm actually looking forward to just pulling a paycheck for a couple of weeks and not having to worry about
There we go. Got that dealt with. So let me see. I can knock cord up a little more. There we go. Now I'm going to be playing with the sound in the background to get more clarity.
Please state the spirit of full name for the court.
First name Michael, Michael. Last name Sprinkle, Sprinkel.
Oh,
Good afternoon, Mrs. Sprinkle. How are you currently employed?
I am employed as a deputy district attorney at the office of the Fulton County District Attorney here in Atlanta, Georgia,
And how long have you been with the district attorney's office?
since June of 2011, so about 14 years.
And what unit do you work in?
I am in the unindicted homicide unit.
And what are your job duties and responsibilities as a deputy in the unindicted homicide unit?
I oversee the unit, the unindicted homicide unit, which screens the incoming homicide cases that come from the various jurisdictions in Fulton County. And I screen them specifically prior to their presentation to the Fulton County Grand Jury.
And in that role, have you at times worked on cold cases?
I have.
And within those files, have you had to enhance audio or video recordings to assist with your investigation or looking into that case?
Yes.
I want to direct your attention to the Melissa Wolfenbarger case. Did you have any occasion to work on that case?
I did.
And within that, did you have the occasion to enhance a September 12, 2001 Henry County interview video?
Yes. Well, yes. It was on I obtained the original video. It was on a video cassette, like a VHS cassette. I had a VCR in my office, and I also had this little USB device that had an RCA connection on it. So essentially it made it so I could hook the VCR up using RCA cables to my computer and then record it. And in doing that, I extracted the audio specifically off the VHS cassette. And I don't recall what exactly I did. I just know that I created an audio file that I could hear better than when I watched the video cassette originally.
And was that able to help enhance you listening to the audio that was on that video cassette?
Yes.
Okay. And have you had the opportunity to review that audio that you extracted in preparation for your testimony today?
Yes, there was a disc, an optical disc that was handed to me outside the courtroom. There were 2 files on it. And I listened to them, and they were the audio files. There were 2 of them. One was an excerpt from the audio file that I created, and the other was the full audio file that I created.
Your permission to approach?
Excuse me?
Permission to approach.
Go, yes.
I'm going to show you what's in Margaret Stacy's Exhibit 73A. Do you recognize 73A?
Yes, this is the disc that I just described.
And did both the original audio and appear to be the full audio that you extracted from this September 12, 2001 video?
Yes, it hadn't been altered or manipulated in any way.
Okay. And then was there a redacted version on there as well?
The redacted version was on there. That was the excerpt of the original, yes.
Your Honor, at this time, the state would like to admit Stacy's Exhibit 73A into evidence.
Mr. McDermott,
No objection.
73A is admitted.
Permission to publish.
Permission granted. Ladies and gentlemen, I'll just remind you, as I have when we've played audio for you, there may be things that have been removed from the audio. You may perceive that. And I'll just remind you that the fact that redactions have been made is not something that you should consider. And why or what might have been said or why the court caused it to be redacted is not something that you should speculate about. Thank you all.
I forgot to tell y'all. I'm sorry. I have a big announcement. I forgot to tell y'all. My son has decided to close his business and go into a new adventure in life. I will be moving my studio. So it's going to be a little chaotic between now and the end of the month. But just know one day, if I'm in a totally different place, it's still me. I'm moving everything to my home. Okay. So I appreciate y'all's patience and understanding. It's just not good timing. Awful audio. We're not going to get it.
Your Honor, may I object?
Yes, sure. You pause that, please.
Why the objection? Are we doing a sidebar? I think we're doing a sidebar, y'all. Sidebar. Yep, we doing sidebar. We have our first sidebar of the day. By the way, Miss June is our bingo queen, and she is working on her bingo cards for the Donna Adelson trial. So we will have bingo for Donna Adelson. Woo-hoo, whoop, whoop. So yay, y'all. Yay, y'all. So that's awesome. Sidebar and on audio tape. Yeah, there's that audio really sucks, big time. And that's something that may be the issue. We are still also waiting for an update on the Donna Adelson jury selection. Let me see if I can find something on that for y'all. So, let's see. Total of jurors that have been summoned are 300 in the morning, 50 jurors, afternoon 50 jurors, individual pre-screening behind closed doors focused on media exposure, biases, emotional reaction to prior trials. Right now, 64 out of 102 jurors from day one were asked to return for the group selection on Thursday at 11 a.m. Pre-trial publicity means that the major hurdle jurors were questions about Charlie Adelson's conviction and Donna Adelson's attempt to flight to Vietnam. Defense motion for change of venue was denied again, is holding firm and keeping the trial in Tallahassee. So they have 64 out of 102 for the first weed through. So looks like we will be able to start trial on Thursday. I think they're going to try and seat the jury on Thursday and potentially have opening statements either start late Thursday or in the morning of Friday. Thank you for the sound is great. I appreciate that. We have no sound right now, for they are at a wonderful thing called
Sidebar.
There we go. Got my coffee. Lunch will be ordered in a minute. Good to go. Let's see the pickle. I want to hear the pickle again. I don't hear very well, so this is on you guys. Work for me. Like my pickle. Love my pickle. Thank you for my pickle. I do love pickles. Sweet pickles, bitter pickles. I love pickles. That's all. I love the food pickles. That is what I'm referring to. We got a little bit of a pickle yesterday, and we were snorting. We were snorting and laughing so hard I nearly peed my pants.
Thank you for your patience. Just let the jury get clear and then we can.
That drink, that watermelon flavors bite you in the butt. What's going on?
Okay. So just to make a record, the nature of Mr. McDermott's objection was that what was being played for the jury for, I'd say, somewhere between maybe 30 seconds to a minute really wasn't audible, right? It just sounds like Charlie Brown's parents, right? You know, we can tell somebody's talking, but you can't really tell what they're saying. I don't know if the fact that that speaker was facing the jury made it more audible and understandable to them, but I didn't get the impression that anybody really understood what was being said. Mr. McDermott's objection was that it was audible at some point, and if it's audible, it ought to be audible in the courtroom or it ought not to be played. We discussed some variations of how we might address this issue, and ultimately, I decided to take a break because I think I understand Ms. Hilton's representation to be that at various times she has listened to that recording and that it is in its, I guess, the point of Mr. Sprinkle's actions of enhancing the audio was to make the entire thing audible, understandable. And if that's the case in some media, then y'all need to take a minute to figure out how to make it audible in this courtroom. And if it can't be made to be audible in the courtroom, then I'm not exactly sure how it's admissible if we can't understand anything being said. The fact that he gave a statement is already in evidence on that date. So.
You know, after a parents locked me up like 8, 9 times, so. So I don't have a good relationship with them at all. Kind of scared about that part of the other angle where it's not good. But, she put all everything was really managed for this for a while. And you got to I don't know what to make of the living. We live in Atlanta.
Can you all understand that?
That was just a picture we can walk around. And,
I mean, I can understand it better than I could before, to the extent that audio quality is always an issue.
Best one to the middle. That's 10 minutes.
She's there. I mean, she's probably around that same area, but
that's 16 minutes.
But I mean, people
that's 20 minutes.
If it's the same quality all the way
anybody I'm telling you right now, you
the judge thinks that's all.
That's about 25 minutes.
Okay.
Now, I just want to start at the beginning just to see how far.
Thank you.
So it's probably about 120 where it gets clearer, about 1 minute and 20 seconds. And the intro is him, what I can hear here is him just getting his name, where he lived. And that's the first minute.
Okay.
So we would propose starting at about 1:30, 1 minute and 30.
Is there any, forgive me if that's what you've just said, Ms. Hilton, but is there any understanding about what it is that was being said before that no one can understand? Do we not know?
So I can hear what he's saying. What he's asking is his like contact information in the first minute. He's asking to give me a little bit of background of their history. The detective asked him go back over your history, and then he started.
Okay.
And that's kind of where this is really where he starts talking about their history.
Okay.
And we're at a minute and 45 minutes.
Okay. So what is the time designation on that tape that you're going to start playing?
I'm going to start it at 1:40 or 1:35 to the end.
Mr. McDermott?
I'm still not happy with the quality of it overall. I think asking the jury to sit through 20 to 30 minutes of that is going to be, its own form of torture. And I don't necessarily see the probative value of it because so little bit of it's audible, you can pick up bits and pieces. That's not a fair copy of an interview, I don't think. It's certainly not anything that would get close to the rule of completeness. So I would still object to playing it at all. If the court has determined that that's audible enough for the jury, obviously that's your call. But I maintain the objection not to play it at all.
Okay.
Furthermore, we've heard testimony from Detective Stott, who gave fairly detailed notes of the interview, and he gave us a pretty thorough down of everything that was said in it. So I'm not sure what's going to be picked up from listening to this tin can version.
Ms. Hilton?
Yes, Your Honor. If Carl Mr. Stott couldn't remember certain things that I asked him as far as dates, I asked him specifically about some dates, specific things that Mr. Wolfenbarger said about relationships.
You're good, love.
Relationships that he had with the Patton family. And there were just things he did not remember. I believe I asked him towards the conclusion, does the entirety of your statement, would that be the fairest representation of your interview with Mr. Wolfenbarger? And he said yes, because everything that I asked him, he did not remember the full contents of this audio, of this video interview from 2001. And we do think it is relevant to play the video was in. What we're now doing is trying to, that the jurors can hear the audio from that video, so that if they wanted to play the video, they could play
Is
it.
it my hearing aid
But
or
here
is
is
it
the
cutting in
audio
and
that
out?
that goes along with this video. And the redactions are redactions in which we advise the defense that we were taking out certain portions. The portions that are redacted from the video is Mr. Wolfenbarger's criminal history. Those are the things that are out, but everything else is what Mr. McDermott agreed should be in. A matter of fact, he asked for us to add something in that we had taken out that referenced Mr. Wolfenbarger's criminal history. So we believe that this is a depiction so that the jurors can hear fully what Mr. Wolfenbarger said in 2001.
I guess my final point would be that, well, yeah, I did agree to some reductions. Those are not the issues we were talking about here. My final point is this we're playing something for jury that sitting here listening to, and we can pick up some pieces, some of it we can hear, we can't. Some of this interview I consider exculpatory and good for the defense. I'm sure the state considers good for their case. We have no idea what the jury is going to be able to hear or not hear out of any of that. And it's just not, you're taking a crapshoot. And I don't want that going before the jury. If we have a clear version of that, then I wouldn't object to it. But there's just no way of telling what anyone's going to pick up from that. And that's not a fair put before the jury.
I think that goes to weight, not admissibility, Your Honor. They can argue that it's not clear. They can argue whatever. They can blame the state for the bad audio. They can do things, but we can put the speaker up there and they can hear whatever that they determine that they can hear, and the defense can do with it.
This is driving me crazy. I do not.
I mean,
I'm not happy
you're not
with
wrong,
this.
In terms of the defense can use it against you if they choose to, right? And make the arguments that Mr. McDermott wants. I'll say that I think the thing I'm frustrated by, and I blame it on the technology, not on the thing I'm frustrated by. If you can play it on your computer and hear it, right, and not in your garbled state that it is, why can't we? That's what I'm frustrated by.
As I played it a few seconds ago, we were able to hear it. I mean, I know most of
Is that what the audio sounds like or whatever?
Yeah, I mean, I can hear the words.
Except that you're telling me that, like, you're telling me things that are being said at the beginning of the video that I can't hear. That's what I don't understand. And it's not that I can't hear it. I can't make out anything, and I don't understand why you can if the court can't in an audio quality issue, because
I'm bringing this speaker up closer so that we can hear it. I can hear it. I hear him, and maybe because I know what's happening, and that could pop to this starting at different points. I think everyone heard everything. That wasn't hard. What was being projected on the audio?
Okay.
Would be willing to put the whatever they can hear, and that's my argument.
Right, but fitted with appropriate audio. Whatever's there is whatever's there, and whatever the jury hears is what the jury hears based on what's there, and that's just a sad fact of life. So your objection is noted for the record. It's overruled. And you're going to start it at the 135 mark. Okay, if you'll go ahead and cue that up at the 135 mark.
It's ready.
Okay, so all you have to do is hit play?
Yep.
Okay. So can we have our jury back, Deputy? Thank you. Oh, can we have our witness back too?
I'm looking to see, can y'all hear me? Because I can't hear me, but I'm looking to see if I can find another feed. Just saying. New tab. I'm going to get rid of that tab. Yeah, they're going to have a fence. DA should have cleaned the audio. It may not be cleanable. That's the problem. It may not be cleanable. I'm looking. Okay, we're waiting. Okay, there we go. That's the best I can do. Good. I can't feel or hear myself with these ears, like talking and hearing nothing. So if I'm too loud, let me know. Hi, Frankie Leroy.
I don't have a good relationship with them at all, kind of figured out, that's why you know that, and we'll talk to them. But, I'm gonna keep it on, yeah, really nice, for this, for a while. I was living, I don't know where Becker was living, we didn't live in Atlanta. That was just a 50% walk. It just, I don't know, get up to, get up. Okay, no, okay, her sister kept telling how bad she had a lady and how bad it's not. You know, she kept putting thoughts for this and that, like, maybe you will, happening and all. Why would I be in a shit mode, no drugs and like that? Get her sister that sort of thing. I would never get something. Then, this time around, she just cool. Thank you. Up until, later on, there's a couple months closer, they got the light, and she had to work in this walk route up there on Yorkville. And she knows, yeah, I took it with her. I guess they got screwed and whatever, and, she come on, she put it out the road, or walk out, but he worked. Just had it, and she took long for 3 or 4 days at a time, but when we had a restoration. Then, she just come back, one of the days, she was, give it to them on top. All this happened about the same time as, this was right around Thanksgiving, remember that? I was thinking it was 99. I'm gonna say, come back. She doesn't want me to come back with me, but she stayed there like a week. I guess that was just to get her stuff. And she stayed there. She left and come back a couple days later. She come back and it was a long talk that night. The next one I looked up, she didn't get all that. Left. I believe mine in her morning train, but I struggled with 4%. He got off the 5 points for me. She took one over. You got to do where you're going. So 98, somewhere around Thanksgiving, that's where about 7 weeks ago, I'm saying, yeah, it didn't have anything on it. Yeah, just wanted to know. I got everything here. So, what do you do? April 24. I lived at one down, we lived at one First Street. Whatever all those now. at that time, I was looking at 8.3. She worked at, the first one she worked with, I really don't know why she, to this day, I don't know why she went, just really, like, then in the young time line. She got a water train went all the way up to Dorothy. And the only reason she made me at that time was, because it's right off the water train. I mean, there's a bunch of them. I mean, to this day, I'm thinking, I'm saying her and sister, she never let me on that, so. I don't know if it was gas me from the floor or what, I don't know. If you say we were out so they really sporadically, yeah, I'll say it's almost, it's almost, because it was right around, it was almost Christmas, I remember. Then she, after she left, I didn't hear too much from her for, a couple more months, or whatever. Back in, April, the following year, which I guess was 99, I think, and I was coming down this street, almost, about the line like that, but right there, probably the train station, I was coming up through there, and she was walking the road, and this is a white girl, on the horn, just, we're 90 degrees around there, but, I thought, and I blew the horn at her, I got down the road about 50 cents down that time. I knew it was, I couldn't believe it. I don't know, I guess, her sister could tell you how she looked. You got to picture how she looked when she was rocked. Yeah, that was like she looked like after we got married. She put her hair short, got it, and we're started smoking, so she was over there. When I said come on, she wants to wait in the number. She could believe it was her heart. We stopped and she just wanted to talk. We went to Taco Bell, whatever. And every time she was like, I knew they ain't gonna come back home. I was like, we're going to be emotional, so whatever it's going to me, and just like this, better off. I just move on, man. It looked like she like tracked herself from home. Yeah, I don't really key up on all that, She looked horrible. She was there telling me what was going on and all that. Basically, what had happened was, from the conversation I had with her that time, she got a really good guy, right? And you see what they put the talk to me, like all these people were living in one house, like 5 or 6 living in one house. And, just the part of my house, you go out and party and see everybody all the time. And she was like, she felt like she was missing out on all that. Didn't she? What she wanted to do, and she I was right. When I told her that, I thought I should do it, you really do, all your mom or your sister or somebody, I look to communicate with the kids as well. Never, she hasn't been. I mean, that's my mom, but she never really, ever, from the time that she found over, she never really told me nothing. From day one, and it's odd, and she didn't even want to have Joey, she wanted to have him aborted. I wasn't do that. As soon as I got Christmas, the trouble up there, you saw, we know we were there, we still, and like that,
That drive me crazy, y'all. I ain't kidding. I ain't no lying. It drive me crazy.
She was real naive, I don't know that way, but not quite. Part of that, she basically, if you could put it idea of it, you would think about it, she would swear it's right. That's, I guess it's when she was a problem, she was running away all the time. But she was a real follower. When you saw it now, you was still working with, everything like that. I really did want to know a whole lot.
None of us can understand what's being said. Not a single one of us. But they have to play it for court. Oh, God only knows.
Dialysis.
So not
First one I want to say is she followed. But I've never seen it. I've seen her call mom once or twice. I mean, I never feel like that. I seen her. She said she used to send her mom calls and all the time. I wasn't down. I don't really know. I did not. All I got for 130 days, and then I remember that.
Too long.
As far as the last name, I think.
Yeah, I imagine the transcript too.
That she was messing with. I know the other night she lived in Shadowford Lodge, more there. That's why I went there. Whenever her mom did say she was coming back with me, when I went there to pick her up, we at Shadowford Lodge. That was where I went to get her. She said that was, they had she was having an argument with the guy right there, right? That's where she just, when she went with him, that's where she was trying. She was all up around that area. I mean, we never knew anybody in that area. What would she be doing now? I can't find anywhere. I can't find where he was. You know, for Social Security, whatever. But the only time that I know that she would, like I say, we've been here, that's all I can think of. Not really want to know. It's just my opinion. If she went through, because to this day, she still ain't. I'm just now, I just want to divorce for her. The only thing I can figure she might have done is changing that. She knows how to do that. The only thing I can see is that she changed it and she got married. And she changed it. Yeah. It's never real easy to work. It's good. I mean, you get probation. You don't probation. Yeah, that, and I all kind of, heard through now a little bit once because they want to vote for that. Or I guess you just look at the court for a few things and there's some kind of, there's another that you find you go looking for. There's a man and a woman for the door. Okay. Looking for, is that about the same kind of thing you got with how we use direction? She's there, I mean, she's probably around that same area, but I don't have no way to do that. Everybody is, we didn't have any friends or anything, but we don't. Maybe associated with a whole lot of people. Is anybody else, any other family member, we probably know who, that she would talk to, there was something she used to talk to all those listeners. And that was, because we didn't really know anybody. We really didn't right over it, we didn't have friends around there. And, we go like get together with a couple of families, and she had all this history. It's my understanding, I haven't ever seen it, my little sister and mom told me that she wrote my sister at name. Whether they still have this night or whatever, they're saying, but I didn't see it. But my sister told me that she already knows explaining all of what was going on. And this apparently is after she was I don't think too much.
Hi, it's not real. I pray that your aunt recovers and is out of the hospital soon. We're so sorry that she is there, but it's so sweet of you to go and visit her. We'll be here when you get back.
Where she stay? I already know that, Canberra, that's American. I mean, and when Pat was said, hey, come over and know how this, you can ask my sister, you can ask my mom, I know, my mom never did that, I want to take me to under the, and she goes like, you can answer, I know you did, anytime I get to, it's just hard. The only time I really have to get some therapy is my still very busy with different, I'm therapy for weeks, that's okay. That's, I don't know, I'm home, you got that's really hard. You gotta approach that, that's the way you do approach it. Take care of it. Everything you know about it, everything. But yeah, you can learn private school, everything. I mean, I don't know, and I mean, I would have called her mom, and talked to him, but every single time this passed, out of every single people, and then you locked up like 8 times, her husband had stopped and beat the crap out of me, and I was in the parking lot, that's the last time I ever seen him, and I'm like, I'm trying to go over there, so. I swear, after you stop coming by there, cause every time you think you come out of the home, I call for it, on there. And, there's one time, when the mom, I called her to start with you, but she goes. I mean, I kind of went and personally, that this girl and y'all was involved with y'all, and mom was it. Don't get involved with it, that was all done, y'all, and we got to understand that, but at the same time, I kind of wonder what the all was doing. I swear, I believe she got this from mom. Her mom was making it out like she had a really good relationship with her. She did. They really did. They had never, I mean, I guess she was trying to build a relationship with her sister. I felt like she would have got this with her sister a million times before she got this with her mom. I mean, the last time I know where her sister was, she was living in Memphis. And I think, and it's my understanding, I don't know for a fact, but it's my understanding her sister moved. I don't know that. But I mean, these people always hate me. Her sister also, they all, and her sister, you look, anyway, but her sister, is always about that fight. I hope, something she got on her. But her sister went through one time, and finally, I was their car, and told all their family that I come over there after car one night, and then come up later on with the night upon me, someone told me, we had the car.
Well, technically, they should have that recording back there with them so they can maybe hear it in a closed room on a computer and get maybe better sound versus being played through an amplified speaker system. Hold on.
I know it's important to believe, and they're really not. And it's like you say, That's true. I don't know if it's suicide or something like his name is. I don't think she committed suicide. This girl is really strong. That's one thing I can say about her. She was really, she had the, and I don't know what word I'm looking for, she had the endurance. You know what I mean? Just with her sister, she's coming up. Her sister, like, had a baby in the bathroom, and just kind of like, she took baby in the fall. Melissa found it like 3 days later in the gym bag. You know, that was one more strain. You know, she was Wolfenbarger as a best friend. You know, and there's nothing there to be done about it. She had a really strong mentality. That's good, you know. I'm happy to know her, but I don't know. As far as the label goes, she can't be at all these people. I don't, you know what I mean? I don't even know if she got any of these people. Not just some bad people.
Right now, there's been no transcript placed in evidence. If the transcript is not placed in evidence, then no, they do not get it.
There's something bad in it, but I swear, I don't know how. I really don't know if her sister put it in the up there, or how she got in the door there, and how, period. So we didn't know what like that. And later on, I mean, a buddy of mine had moved up that way, that was not, it didn't have anything to do with her. One name which is, probably a doctor, was trying to. Because, I mean, that's the reason why we get these real quick with family. Because she can move, she can be in, she knows that she got the real, she got, she can do it. I don't know. I mean, it's like, I think things would be a lot different for you. There are a lot of people, you know, if we say like, well, let's go to the little town, you know, we do whatever, or something, and we kind of do this, we do this a lot, and everybody. Oh, you know what it's doing, you know, when you just pass, you go off the wall, when you shoot, I was thankful for y'all, I mean, how you talk to you, like, you know, I mean, I come up, you know, this is the first time I ever really talked to that woman like that. Ever really, she always, it couldn't hate me, it really, she cannot stand me with everything. And I don't, you know, this is, right we got married, and I will, you know, I just talk about and tell about like, because at that time, she was telling me all everything, what, you know, happened and everything. So, I mean, that was the first one that I really, you know, kind of, we really talked, you know, and it just blew me away that they had not talked to her at all. I guess that's mom, because I was very shocked. I'm like, there's no way. I mean, I used to work with her daddy when we first got married, and I used to always say, I'm not doing what. If people really had time, I'm going to say, they did out for anything, the insurance fraud, stuff like that. They ever put out a TV, so they said you did something to her, or, you know, something like that. I haven't talked. I try to stop. I try to avoid people, but if any kind of interaction I've ever had with any people, if you got me beat up, I put in jail. And for me, I mean, it's kind of a strange thing when you know how we even got married, because it's like, in my mind, it's just like a little, and it's like, I hate married this girl, you know, I'm good at everything. You know, it's just crazy. Well, I don't know, I mean, it kind of was like, for a while, you could have done something about it, or whatever, you know, just you want to use the low days, getting kind of stories that happen, you know, all those days, get the beautiful, like you said. You guys, if you go to anybody now telling you right now, you can ask anyone or anybody that's around there, they'll tell you the same. I mean, there ain't no way I want to do what I'm going to do. So yeah, we live in another one part of the Congress. So of course I want to get on. When did you find out that she was reported this? Or like that program is I think the very first time you come out of it, I think you spoke down, I don't remember, is that correct? I think probably a whole year. I mean, and I gotta tell you right there, that she didn't have a relationship with mom, so mom was saying she did, if there's a whole way, the whole year. You know what I mean? There's no way. So that's, that's where this came out of. It just looked like a situation where you got somebody that goes off and does whatever they do, maybe a drug addict or something that has, maybe they're going to do things. But I thought, they say now after a year, you have to kind of make you on the wall, find out, but still, somebody, like this, or there's something bad that happens. And I mean, that might have been all the, I was sitting here, and you don't know how long I've been sitting here, just going over scenario after scenario, trying to, figure out what it is, especially now, man, it's what it is now. Actually, we found her mom, she didn't tell her mom. But the only thing, which I was sitting there all ill with, we did this thing, we changed the name and everything, was the only thing I kept saying is, at the time that we had it set up, we went to money and all that, and, so we not, I'm proud of that, but he was like, you gotta cut off everybody you know that, I could kind of say that, if indeed, she put that, she put that, and all that, she knows she was like, but she had to, that's not everybody.
Okay. We're going to take a break from all that recording. I'm just going to let it run because I can't handle any more of it mentally. I'm about ready to start playing Animal Crossing just to give me a mental break. But we've got Donna Adelson movement. They're coming back from lunch.
Go ahead.
My old office manager contacted me last week or the week before saying that she thought she had received a summons when we got the jury list last week. She was not on it, so I didn't raise it. Although I previously said something to the state. She's number 86. Or 186, yes.
Councilman, concerning this, do you still wish to inspect the prospective juror?
All the way up.
And this is number 186, you said?
Yes, Your Honor. She worked for me for over a decade. I did work for her and Allie. So I don't suspect that the state would choosing her.
Well, please let them know downstairs 186 is excused from further consideration.
Thank you, Your Honor.
All right, if we're ready to bring them upstairs, let's move forward. We'll start again with 1. Yeah. Okay.
Keep talking, Judge. I need to hear you. I'm trying to adjust the sound. I need some talking. I need the judge to talk so I can make adjustments. Come on, Your Honor. They're off mic. I'm going to go back to the other trial until I hear better.
All right, quick 2-second bench.
Sure.
She's got her pearls on. So we got a sidebar. Y'all, I'm about ready to start playing Animal Crossing. We'll see what goes on in the courtroom and see how it sounds when he starts talking. I know, Angela. Well, they don't have as many as some trials have, that's for sure. And this judge has her robe on. She's all in black. It all look good. So we'll see. All right, I'm going to play. Just for the heck of it while we're waiting. So now I got to go find one of each of those hot items. Let's see if I have it. Wooden chair and garden bench. Let's see if I got them. Well, not there. Let's see if I have a garden bench over here. I don't. Log chair, that chair. I don't have a wooden chair. Oh, well. I'm gonna go
Stand, ma'am, and
snorkeling.
when you get there, if you will, before you have a seat, turn around and face the deputy and raise your right hand. He'll swear you in.
Do you swear upon truth to tell the moment that you're about to get truth, the whole truth, and nothing but the truth, sir?
Yes.
Merci.
Rosa, Rosa, James, James.
Did you already do the instruction on?
My understanding was after you had qualified
Oh, okay.
or attempted to qualify her.
Thank you.
Thank you.
Good afternoon, Ms. James.
Good afternoon.
How are you employed?
I'm currently employed, self-employed at my consulting company called Sania's Place, LLC. I was going to spell it. SANIYAH Place, LLC.
And if you can tell the jury your job duties and responsibilities at your consulting firm.
So my job duties as a consultant is I'm a researcher, practitioner, and also a trainer for intimate partner violence and gender-based violence. I also do sexual violence and child abuse. I do trainings, I do presentations, panels, whatever the community needs me to do. And I also do expert testimonies.
And how long have you had your consulting firm?
It's been open since January of 2023.
And if you can tell the jurors, how long have you been in the space of working in intimate partner violence?
I started working in the intimate partner violence movement in 2012.
And just tell the jury about your education, your job training in intimate partner violence.
So I started working in the intimate partner violence movement in 2012 at Harbor House of Central Florida. That is a local domestic violence center in Orlando, Florida. And then I continued throughout I continued to the Florida Coalition Against Domestic Violence. And then I moved to the Georgia Coalition Against Domestic Violence. And that's how I got to Georgia. My education background, I have a bachelor's of Science and Legal Studies from the University of Central Florida. I have a master's of social work from the University of Central Florida, which is a clinical program. I also am currently finishing up my PhD at Clark Atlanta University in the social work program, policy and organizational leadership. From the Georgia Coalition Against Domestic Violence, I transitioned to the District Attorney's Office as a domestic violence trainer in July of 2019. And then when Madam DA came into office, I became a senior advocate, senior victim witness advocate, the domestic violence trainer, and domestic violence expert.
And you said you're currently getting your PhD at Clark Atlanta?
Clark Atlanta University.
And are you currently at the dissertation stage?
Yes.
What is your dissertation on?
My dissertation is on intimate partner violence, Black women in service delivery of the local domestic violence centers in Georgia.
Now, you said that you served as a trainer at both the Georgia Coalition Against Domestic Violence and the Florida Coalition Against Domestic Violence. If you could tell the jurors, what type of training have you conducted?
So the foundation of the trainings that I conducted at those two coalitions, they statewide coalitions, is I trained advocates to service survivors of domestic violence. And also these trainings lasted 3 days. On top of that, I had to train the community members as far as healthcare, different systems like healthcare, law enforcement, even in Florida, prosecution offices, any community members throughout the state of Florida and throughout the state of Georgia about domestic violence. I also trained advocates on protective orders. In Florida is injunctions. We train them how to be legal advocates in a sense where they have to help survivors with their injunctions as far as helping them through the court process. And also I've done trainings on queer community and domestic violence and basically a vast majority of intimate partner violence, child abuse, and how all that relates to gender-based violence.
And over your years of working in the field of intimate partner violence and gender-based violence, have you met with and spoken with victims of intimate partner violence?
Yes, I started in 2012, and that was immediately contact with survivors and through face-to-face trainings, hotline calls, well over 20,000 contacts with survivors of domestic violence.
And I said victim and you said survivors. Tell me why.
Okay, so I go to a comfort break and this court comes in. I'll be right back, y'all. Take my ears with me.
Everyone can be seated.
Okay, I'm back.
Good afternoon, ladies and gentlemen. Oh, that will not do at all.
Again?
Let's start
He does this every time.
again. Good afternoon to all of our prospective jurors that have answered the call to serve. Thank you. Much better. I'm Stephen Everett, one of your circuit judges here in the Felony Criminal Division for Leon County. You have been summoned here this afternoon as prospective jurors in the case of the state of Florida versus Donna Adelson. This is case number 2023 CF 3226. This is a criminal case. The state has charged Mrs. Adelson with the crimes of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. You will notice at times during this jury selection process that I will be reading to you. It's not that I do not wish to have a free-flowing conversation with the members of our prospective jurors as a panel as a whole, but rather the instruction on the law that you're to receive during this process must be uniform and it must be specific according to the Florida Supreme Court. Is the state ready to select a jury at this time?
Yes, Your Honor.
Is the defense ready to proceed as well?
Yes, Your Honor.
And for the record, I'm noting that Mrs. Adelson is present in the courtroom with her attorneys. The first thing I'm going to do this afternoon is to confirm the information that took place downstairs during the qualifying. Tricia, who performed the qualifying this afternoon? All right. I believe you earlier spoke with Judge Riggins. You all remember Judge Riggins, correct? All right. The information that you went over with Judge Riggins, I'm just going to confirm to make sure that everyone is eligible to serve. And also as well, no one needs to be excused at this point for statutory reasons. Please raise your hands by answering yes to the following questions. Are you at least 18 years of age or older? Every hand should be raised unless you're 17. Please raise those hands again, keep them up so I can actually see them. For the record, the prospective jurors have answered yes to the question. Are you citizens of the United States of America? For the record, the prospective jurors have raised their hands and response is yes. Are you residents of Leon County, Florida? Once again, the prospective jurors have raised their hands yes. Do you possess driver's licenses or identification cards that were issued by the Department of Highway Safety and Motor Vehicles, or have you executed an affidavit as to your eligibility to serve as a juror? Once again, the prospective jurors have raised their hands in the affirmative. If your answer is also yes to any of the following questions, please raise your hands as well. Has anyone ever been convicted in any state or federal court of any felony crime or a crime of dishonesty, and you have not had your civil rights restored? None of the prospective jurors have answered in the affirmative to that question. Is anyone at the present time under any prosecution for any crime in either a state or a federal court? None of the prospective jurors have raised their hands in the affirmative. The next set of questions that I'm going to go through with you are bases for which someone can be excused from jury selection based on their status. If your answer is yes to any of the following questions, please raise your hand. Is anyone a full-time sworn federal, state, or local law enforcement officer or investigative personnel? No hands have been raised in response. Is anyone an expected mother or parent responsible for the full-time care of a child that is under 6 years of age? No hands have been raised in response. Is anyone 70 years of age or older? No hands have been raised in response. Has anyone performed state jury service within the past calendar year? And I'm referring to August 20th, 2024 to the present. No hands have been raised in response. Is anyone responsible for the full-time care of a person with a physical or mental incapacity who is incapable of caring for themselves, and you being present here is creating a hardship for them? No hands have been raised in response. Is anyone a full-time student between the ages of 18 and 21 years of age who is attending high school, any state university, private post-secondary educational institution, Florida college system institution, or career center? No hands have been raised in response. And finally, the last question. Has anyone given birth within the 6 months before the reporting date on your summons, which would be today? No hands have been raised in response. The first thing that we're going to do this afternoon is to discuss what you may know about this case. This case has received publicity, and there also was a related case that took place about 2 years ago. This process is going to be handled individually because you don't need to know what others may know concerning this case. However, before we start the questioning, I need to give you some very important instructions. Many of you have cell phones, computers, and other electronic devices. Even though you have not yet been selected as a juror in this case, there are some rules that you must follow about using your cell phones, electronic devices, and computers from this point moving forward. You must not use your phones or devices to search the internet or to find out anything that is related to this case. Between now and when you have been discharged from jury duty, you must not provide or receive any information about your jury service to anyone, including your friends, coworkers, and family members. You may tell those who need to know where you are that you've been called for jury duty. If you are picked for the jury, you may tell people that you have been picked and how long the case may take. However, you must not give anyone any information about the case itself or the people that are involved in this case. You also must warn people not to try to say anything to you or write to you about your jury service or about this case. This would include face-to-face phone and computer communications. In this age of electronic communication, I want to stress that you must not use electronic devices or computers to talk about this case. This includes tweeting, texting, blogging, emailing, posting information on a website or chat room, or any other means at all. Do not send or accept any messages, including emails and text messages, about your jury service. You must not disclose your thoughts about your jury service or ask for any advice on how to decide the case. Further, you must not read nor listen to any news accounts about this case until you have been excused. Avoid the newspaper and television broadcast, particularly the local news stations. Also, avoid social media or any internet news sites. I am now going to provide to you a statement of the case that has been agreed upon by the parties. On July 18th, 2014, FSU College of Law professor Dan Markell was shot while seated in his car. This happened in the driveway of Markell's home on Trescott Drive in the Benton Hills neighborhood. The killers traveled to Tallahassee from Miami to commit the murder in a rented silver green colored Prius. The defendant and alleged conspirator in this murder was the former mother-in-law of Dan Markell. She has entered a plea of not guilty. I will also now read to you from the material part of the indictment that has been filed against the defendant. Count 1. It is alleged that on or about July 18th, 2014, Donna S. Adelson in the county of Leon and state of Florida did unlawfully kill a human being, Daniel Markell, by shooting with a firearm, and the killing was perpetrated from or with a premeditated design or intent to effect the death of Daniel Markell. This is contrary to the Florida statutes. Count 2. It is alleged that beginning in 2013 until October 1st, 2016, Donna S. Adelson in the county of Leon and state of Florida did agree, conspire, combine, or confederate with Charles Adelson and or Catherine McBanois and or other persons to commit first-degree murder contrary to the Florida statutes. Count 3. It is alleged that beginning in 2013 until October 1st, 2016, Donna S. Adelson in the county of Leon and state of Florida did solicit another to commit first-degree murder, and in the course of such solicitation, commanded, encouraged, hired, or requested the person, Charles Adelson and or Catherine McBanois, and or other persons to engage in specific conduct which would constitute first-degree murder, which resulted in the death of Daniel Markell, contrary to the Florida statutes. The statement of the case and the indictment that I have just read to you are not evidence, nor are they to be considered as evidence or any proof of guilt. You must not be influenced by the statement or the fact that an indictment has been filed in this matter. It is merely informing you of the accusations that have been made by the state against the defendant. We are now going to talk to each of you individually and privately about this case. Some of you may be excused at this point in the jury selection process. Others will be told when to return tomorrow. Individual voir dire is time consuming, but will go a lot smoother if you're prepared to tell us what we need to know. These are the basic questions that you will be asked or some variation thereof. What do you know about this case? What sources have you obtained this knowledge from? Based on what you know, do you have an opinion about Mrs. Adelson's guilt or innocence? Can you set aside your present knowledge, disregard it, and render a verdict solely on the evidence presented in the courtroom. Can you be fair and impartial? Do you have any reason that you cannot serve on the jury for up to 3 weeks? It will save us all a lot of time if you think about these questions and you are prepared to give a prompt answer when we call you back. We are also going to discuss with you individually the time period that is involved with this trial. We expect the jury selection process to last until Thursday of this week. After that process is complete, we expect the trial to begin on Thursday and to continue for the next 2 weeks. In all total, we expect these proceedings from today will take up to 3 weeks. We understand that that is a burden for anyone to serve for that length of time. However, we cannot make our system of justice work unless we have good people that are willing to do their civic duty and serve as jurors. Similar to military service, we do have to call on our citizens to make serious sacrifices. Jury duty is one of those times. You will probably never be called upon again to serve in a trial of this nature or this length. However, I understand for some of you that serving in this case may not be possible. To give you a little more information about what serving as a juror in this case will involve, you will not be sequestered during the trial itself, meaning you are going to be able to return home each day and return the next. For the most part, we are expecting to work a regular business day, but on occasion it may be necessary to work longer based on the witness schedules. I will do my best to adhere to a regular schedule over the course of the trial. So please give some thought to whether you have a major problem, including a physical issue, that would prevent you from giving this case your full attention and performing your duties as a juror if you are, in fact, selected. Please be patient with us. We will be working as efficiently as we can. The bailiffs, the clerks, and court administration will be assisting here in the courtroom. Please follow the bailiffs or clerk's instructions. Do not discuss this case while you are waiting or anywhere else until you have been excused. Do not read or listen to any media accounts on your phone or anywhere else until you have been excused. Also, while you are waiting to speak with me and the attorneys, you are not to speak to your fellow prospective jurors. You may read your phones. You may read the reading material that has been provided in the form of magazines, but you are not to speak with each other or discuss any matters concerning the case. If the parties can join me in the juror room, we will begin the process.
Okay, at this point, they're going to go bye-bye. We're going to go back to the other trial because we're going to get to see is the wall or the flag or the clock. So back to the other trial.
Why do you use the term survivors?
So in our world and in the movement, we use survivor because the survivor is a term of endearment. And also some survivors, they use thrivers. They have thrived through the domestic violence. We only typically use victim in this realm, or where I am in the science realm, in the advocacy realm, if someone has fallen due to domestic violence, a casualty.
And you talked about having over 20,000 contacts with survivors of domestic or intimate partner violence. Has those interviews and conversations and interactions assisted you in your understanding of domestic violence relationship dynamics?
Yes.
Now, over your course in working in the field as well, have you met and spoken with offenders or abusers?
Yes.
And can you estimate for the jury about how much contact have you had with offenders or abusers?
So I've had a year of contact with what we would call perpetrators or abusers, because I taught in Florida batteries intervention courses, which is a 32-week-long course that the courts in Florida mandate that if you receive an injunction that you must take.
And have those interactions, those trainings informed you regarding your understanding of domestic violence and the dynamics of domestic violence?
Yes, it has.
Have you ever testified in the state of Georgia as an expert in domestic violence?
Yes.
How many times?
So Florida has been 27, and I'm about to do the math. I want to say around 47, 48 times in the state of Georgia.
Your Honor, at this time, the state would like to tender Ms. Rosa James as an expert in domestic violence relationships, and domestic violence relationship dynamics.
Okay, don't forget, we had a hearing and they discussed and they had, or sidebar, something, and they were not happy about the fact that there was going to be some things that may be brought up, and the defense was very defensive. So let's see. This may be hot and interesting.
Mr. Samuel?
We'll reserve word here for cross-examination.
Okay. So, ladies and gentlemen, Mr. Samuel, come here, please. Ms. Hilton, y'all both come here.
Would you like me to step out?
No, you're fine. Thank you.
That's a good question she asked. They're going to have a sidebar because the guy said, well, I'll wait for my voir dire. I'm like, for his cross-examination. The judge is like, what? That's what we are just doing right now. You don't sit there and voir dire her after she's already testified. Weird. Much.
So specifically offering around 47
Offering an expert like that of all witnesses is to be given only such weight and Ms. Hilton, y'all both come here.
Forces, which
domestic violence relationships, and domestic violence relationship dynamics.
Mr. Samuel?
We'll reserve word here for cross-examination.
Okay, that's what I thought he said. That's weird.
Of Ms. James as an
Okay, that was weird.
The state is offering, excuse me, I'm sorry. The state is
Hey
offering
there,
the
Brooke.
testimony of Ms. James as an expert witness. And so at this moment, I'm going to just instruct you generally that people who testify as experts are testifying because the proponent of the evidence believes that they have specialized experience, training, knowledge in a particular field that's not common knowledge or known to the average citizen. And the law permits a person who is testifying as an expert witness to give their opinions based on that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise, and testimony of an expert like that of all witnesses is to be given only such weight and credit as you think it is properly entitled to receive. Thank you. Please go ahead, Ms. Hilton.
Thank you, Your Honor. Ms. James, can you please define domestic violence for the jury?
Yes, the definition of domestic violence is a pattern of coercive behaviors to gain and maintain control over your partner.
And based on just your training and knowledge, how familiar is the public with the issue of intimate partner domestic violence?
So the public is familiar with the concept of intimate partner violence, specifically the physical aspect, but the science behind that, the science behind domestic violence, the public typically isn't well versed about what's under the iceberg, typically just above, which is physical violence or any type of sexual violence.
And over the course of the years, has there been some type of increased knowledge with the public as it relates to people watching kind of like true crime television?
Yes, specifically, the boom of the internet is information that's there, and through the true crime or any type of documentary, yes, the public can access that information.
However, in your experience, has the knowledge that comes from, say, internet or from podcasts or true crimes, is that the full knowledge or understanding of the science of domestic violence?
No, it is not.
Based on your work in the field, what are some common misconceptions regarding domestic violence?
So the biggest misconception, if the survivor leaves the relationship, the abuse will stop. And that is not true. The data shows that's the most lethal time in the relationship. That is when the survivor is under the most danger and most likely to be killed. So that is a misconception. The abuse does not stop just because someone leaves the relationship.
And based on kind of some of the trainings that you've done in your experience, what are some of the beliefs about why an individual may remain in an abusive relationship?
So there's a host of concepts and in theories and perspectives of why someone would remain in an abusive relationship, the biggest factor is power and control. This person has exerted power and control, and the victim or the survivor feels as if they have to stay and remain in this relationship. Also, there's a component of fear and protection, protection of children, protection of self, protection of family members. It's many different dynamics of domestic violence why someone would remain in that cycle of abuse.
And are there any is there any research about how long it usually takes a survivor to leave an abusive relationship?
Yes, the research state on average, it takes 7 times to fully leave a relationship that is abusive.
Now, are you familiar with the term or the concept of the cycle of violence?
Yes.
How are you familiar with the cycle of violence?
So the cycle of violence is a cycle that shows how a survivor would remain inside or trapped inside of a abusive relationship with their partner.
And is there a demonstrative that you sometimes use in order to explain the cycle of violence, or is it also called the cycle of abuse?
Yes.
You have permission to approach?
Go ahead.
I'm going to show you what's been marked as Stacy's exhibit number 79. Do you recognize Stacy's exhibit 79?
Yes.
And how do you recognize Stacy's exhibit number 79?
This is a cycle of abuse. It's an evidence-based tool we use in our practice to show how survivors stay in relationships.
And will this demonstrative assist you in explaining the cycle of abuse to jury?
Yes.
You're at this time to state like the admit Stacy's exhibit 79.
Mr. Samuel,
No objection.
79 is admitted.
Permission to publish.
Permission granted.
I guess they're going to be showing us a PowerPoint presentation describing the cycle of abuse.
And it's basically a conversation back and forth between the survivor and the perpetrator where they're getting back into the relationship. It does not have to look like a honeymoon phase where you're getting flowers and all these things. That's why we no longer really use that term anymore. And that's why we use the phase calm. So in this phase, most likely the abuse is forgotten, the incident is forgotten. We just move on with life like this never happened. That's what I see the most in my field, in my personal observation in the field that I work in. It's just forgotten. It didn't take place. These things happen in relationships. We move on. But like I said, it doesn't always look like, oh, you're getting flowers, you're getting presents and gifts, and it's all love. No, it doesn't always look like that. Sometimes it just looks like we're moving on with life.
And you kind of talk about in the incident phase, it could be verbal, emotional, and physical. Is it usually one of those three, verbal, emotional, or physical?
It could be a whole host of things. It doesn't always have to be fit into that box because domestic violence is not a box. Every relationship looks different. Every incident looks different.
Now, in the field, is there also a concept of the power and control wheel?
Yes. The power and control wheel was created in 1980. It's a qualitative tool where 300 survivors were interviewed, and we use ground theory, which is a themes theory, to find different themes, well, similar themes, to create this wheel to show the tactics of the perpetrator.
And have you used a demonstrative of that power and control wheel to explain how an abuser will exert power and control over a survivor?
Yes.
Now I'm going to show you what's been marked as Stacy exhibit number 75. Do you recognize Stacy exhibit number 75?
Yes.
And how do you recognize Stacy exhibit 75?
It is the power and control wheel.
And would that help you today in your testimony and explain to the jury the power and control that abusers use in relationships?
Yes.
You're at this time to state like limit Stacy exhibit 75 for demonstrative.
This is a demonstrative exhibit?
Yes, sir.
No objection to using it as a demonstrative exhibit.
Exhibit 75 is admitted for demonstrative purposes.
Thank you.
Tink is back. Welcome back. I wish I could play that song and I got copyright.
Looking at State's Exhibit number 75. Okay, let me remove them. If you can, and what I'll do is I'll navigate
Over here, just tell me when I need to go up or
up or down.
So
Go down.
That's them guys, not me.
to show like the contributing factors and, okay. Oh, that's,
All right.
mhm.
Okay, so if you can explain kind of the wheel, it's up, and if you could, you may have to step down just because we might not be able to on the external. Yeah. So, to explain to the jurors what.
So I want to explain to you all what this wheel is, but I want to tell you why it's structured this way. So on the outside, so first, this isn't the first wheel. This wheel has evolved over since 1980. And the reason why I use this wheel, because it's a very much gender neutral wheel, because we understand that domestic violence isn't just gender from man and woman, right? It is a whole host of genders, a whole host of communities that suffer from intimate partner violence. And it's structured this way because the physical and sexual violence is seen. Those are things that can be seen, so that's why they're on the outside of the wheel. And these are systems that contribute to intimate partner violence, right? Systems, isms, and things I train about when I'm out in the community trying to help people understand how these different systems could trap someone in a relationship, right? So on the inside, we're going to start with using intimidation. On the inside, these are factors or tactics you may not see when you approach or survive a domestic violence. You may not see intimidation. Mind you, these are all inside the spokes. You may not see someone being afraid of a book. You may not see someone abusing pets or using weapons as threats, right? Putting a gun on the table is not illegal. You may not see the emotional abuse. You may not see that person being put down. You may not see the humiliation, or you may not even think that that person is being humiliated or being exposed in that moment as a form of power and control. Using isolation. This is very important because this happens very early in the relationship. They isolate you to them and their support system, right? They don't want you to have any outside friends. They don't want you to have any outside family. They don't want you to have sisters, sorority sisters, or whatever is your support system. Sometimes this transfers, like it's parallel to economic abuse, right? Your livelihood. So what I see a lot in isolation is survivors being pulled away from their family, right? Being moved across country, or being told that it's abnormal to speak with your family members every day, right? They're trying to reduce your access to people so that others on the outside don't see the abuse that's going on inside the home. Minimize it, right? It wasn't that bad. What are you talking about? I'm minimizing the joke. I'm minimizing what took place. Specifically on the cycle of abuse, the incident. There's a minimization going on during the reconciliation phase. It wasn't that bad. You made it look like it was the end of the world, and it was. Using children. That is a major, major part of why a lot of survivors stay in relationships, because they want to protect their children, right? That is just the natural part of being an adult. And sometimes when there's a separation, because this abuse can continue outside of the relationship. The relationship could end, but if you have that connection with children, we can start using the children as the go-between. We can start using the children as someone else to continue the power and control and the abuse. We can also use children to harass family members, use children to indirectly affect your livelihood, right? Calling your place of employment and things of that nature. Now we use privilege. So this has changed to use.
There's some whispering going on. Are y'all hearing the whispering? Obviously, we've got a sidebar.
We can use the Bible, we can use someone's race, their culture. Privilege can look a lot of different ways.
In economic abuse, I always talk about
They're still whispering.
you must have control of all the money, you must make the most money. No, it could simply be tampering with a survivor's car so that they can't go to work, right? Ruining credit, continuously getting evicted, invasion of accounts. It could look any way, but the whole goal is to take control of your economic livelihood. Using coercion and threats, that's in the definition. I'm going to coerce you to stay in this relationship. Coercion is really used a lot in the queer community. I'm going to out you.
Yo, I don't know why they keep muting, but they do. Get out of my way, dude. Out of my way.
This wheel, the healthy relationship wheel, we have so many different wheels out right now, but it is the same concept, power and control.
Thank you. And in every abusive relationship, will you see every tactic used?
No.
In order to define a relationship as an abusive relationship, does there have to be like a magic number of events or physical violence or a certain amount of times that someone uses isolation to define that this relationship is domestic violence?
No.
How do you distinguish in the field, say, an isolated incident from a relationship that would be considered a domestic violence relationship?
So to explain an isolated incident, we look back at the definition of domestic violence. The definition is a pattern of coercive behaviors to gain and maintain control. That's what it is. And if there is a pattern, it doesn't take, it's an indefinite number, right? We don't have a certain number. We don't have a certain theme for it to fit in. As long as it fits under that definition and that survivor is explaining that relationship from beginning to end or in the middle, patterns of coercive behavior to gain and maintain power and control, or for the perpetrator to exert power and control, we define that as a domestic violence relationship.
Now, is there any literature regarding the various roles an abuser can play during a domestic violence relationship?
Yes, so there is trainings and information out there about men who batter, right? But we still use that foundation for all genders. And in that training and in that information, the roles that a perpetrator will play to gain and maintain that control is the hero, the judger, or the victim. In that relationship, we see that theme continuously circling and circling to show power and control against their intimate partner.
Okay, so you said it's the hero, the judger, and the victim.
Yes.
Can you explain the hero role?
So the hero usually shows up first, right? I'm saving you from your family. I'm saving you from your friends. I'm saving you from economic depression. I'm saving you from food insecurities. I am here to be a savior, to push you forward in life, right? And there's no infinite time on how long that will last. But yes, I'm the hero. I'm here to save this family, and I'm here to save you from yourself. When we think about the judger, let's go back to the hero. I have saved you. And then as the judger, you may say, the survivor may say, oh, now I want to connect with my family again. I feel like it's time. I think forgiveness is the right answer. Then I'm going to judge you for that, right? No, why would I save you from them? Why would you go to some place where they hurt you? Why would you interact with people who harmed you? I saved you from that. So I'm judging you in that because I don't want you to go over there, right? I want to maintain that power and control. So I'm judging everything you do when it comes to seeking outside support. And then the victim is, this is a basic answer of the victim. the survivor is now, perpetrator is like the perpetrator playing the victim. The survivor says, I'm leaving the relationship. This is not healthy for me. And then we play the victim role. Like, what did I do to you? I saved you, and now you're trying to leave me. I deserve closure. I deserve these things because I am the victim here. And you're leaving me for no reason, right? You're leaving me for no reason. I did all these things for you. It exerts this level of guilt that can keep a survivor in the relationship as well.
Is it unusual for a victim of domestic violence to remain in a relationship with the abuser after the abuser physically assaults them?
It's not unusual. It's very common.
And why is it common?
So we go back to coercion, we go back to reconciliation. It wasn't that bad. You did this to me. We could make this work. Everyone has heard the term, this will never happen again, right? So it's a level of guilt that the survivor is hearing, or a level of happiness because, wow, they've told me that this won't happen again. This person is actually owning up to what they did, and now we can move forward in a relationship.
Same question. Is it unusual for a victim of domestic violence to remain after someone verbally abuses or verbally assaults them?
Yes, it is very common for someone to stay.
Is it for the same reason that you kind of just discussed?
Yes. Or even sometimes survivors blame themselves when it comes to verbal abuse or emotional abuse. Like, I deserve that. I really was acting that way.
Is it unusual for a victim of domestic violence not to pursue criminal charges in a case?
It's not unusual.
Ms. Hilton, are you done with that exhibit?
Oh, I'm sorry. Yes,
That's
sure.
okay. If you could take down your screen share.
Yes. And is it unusual for a victim, for a survivor of domestic violence to withdraw or ask for a temporary protective order to be dismissed or withdrawn?
It's not unusual.
Why not?
I want to go back to the reconciliation, that when we're reconciling, right? So the survivor may believe the perpetrator has changed. This is not necessary. This is we're overdoing it, right? Yeah, I believe that this is way too much. Like, I believe that you're going to co-parent appropriately, and we don't need all these parameters. You could be coerced into that, or a survivor can say, well, we're always going to have they told me that we're always going to have a third party when exchanging children. We're always going to, this person is not going to do these things alone with me anymore. So, of course, I don't need this level of protection anymore.
And I use the term a temporary protective order. Can you define what a temporary protective order is?
So in Georgia, a temporary protective order is what the community would know as a restraining order, that you can't be within X amount of feet of me. You cannot be alone with me. You cannot be within X amount of feet. You cannot contact me indirectly or directly. You cannot use family members, friends, siblings to send messages. This is a complete stop of communication.
And in Georgia, to get a temporary protective order, is that a civil hearing? Like, are both parties present when at a civil hearing to get a temporary protective order?
Yes. So you're going to have a plaintiff and defendant, but it's a civil proceeding. It does not turn criminal until that protection order is violated. But it's a civil proceeding. It is done in front of a, depending on the county, a family court judge, or done in the protective orders office to have due process, because the defendant of that temporary protective order gets to deserve, constitutionally rights they are able to do due process.
Now, earlier we talked about kind of isolation as it relates to the power control wheel. Hypothetically, if an abuser or perpetrator moves a victim to a location where she's unfamiliar, has no friends or family, can that be a form of isolation?
Yes.
How can that be a form of isolation?
So that can be a form of isolation because you are moving that survivor away from their support system. You are now around my family and friends, and they will be your influence at that time. So you have no immediate access to any support system when you're moved up and rooted from a place you know and are familiar with to somewhere that's new.
Hypothetically, if an abuser moves the victim to a neighborhood, or a perpetrator, moves a victim to a neighborhood for which he's familiar, he has friends, he has family in that neighborhood, he has neighbors in that neighborhood, and he never introduces his significant other to those individuals, can that be a form of isolation?
Yes.
How?
So that's a form of isolation where you are keeping the survivor in the home or away from the community so that the survivor cannot even create their own community, right? You typically when someone moves to a new community, you end up creating your own community, right? If you don't know anyone, you would be introduced as someone's spouse, and then typically in a healthy relationship, that spouse gets to navigate that neighborhood, join committees, or do whatever they need to do to feel comfortable.
We talked about isolation, and if an abuser, can an abuser isolate you, strike that. If an abuser isolates you from your children, can that be a form of control?
Yes.
Are there times when a perpetrator uses family members to kind of step into the place to exert power and control over a victim?
Yes.
How can that happen?
So specifically, if you're isolated to your partner's family members, they can use coercion as well. They can use the children. They can use these same tactics of emotional abuse and minimizing and threats to keep you in that abusive relationship. They're just doing it from the outside, but they can still be enablers. They can enable the perpetrator's behavior and use the same exact tactics that a perpetrator would use to keep you in that relationship.
In your experience, if a survivor is being abused and maybe her family members, family members maybe see signs of that abuse and they want to confront the abuser, and the survivor stops them from confronting the abuser. In your experience, what are some of the reasons that the survivor will not want a family member to, say, confront or approach an abuser?
Your Honor, I object to individual instances of her experience.
Sustained. You can rephrase if you'd like.
Sure. Hypothetically speaking, if a survivor does not want his or her family member to approach or to speak with an abuser, is that a form of self-protection?
Yes.
How?
So when we think about the dynamics of domestic violence, when we have outside family members approaching the perpetrator, the survivor is going to take the brunt of the blame for that family member or friend approaching and accusing or exposing domestic violence, right? Specifically if the survivor is still living in the home. So it is a form of protection. And it also can be a form of protection for the children.
Now, as it relates to this case, what, if any, information did you have as it relates to this particular case here?
I don't have any information. As an expert, I come in blindly because I'm here to stay within the psychoeducation and the science of domestic violence.
Let me ask you this. Did you know that this was a murder case?
Yes.
Did you read any police reports as it related to this case?
No.
Did you view any temporary protective orders as it relates to this case?
No.
Did you listen to any interviews as it relates to this case?
No,
Did you interview anyone as it relates to this case?
no,
You spoke about earlier that you've been qualified as an expert in Georgia in about 47 cases. In those previous cases, have you had substantial information about those cases when you testified?
no.
Can you tell the jurors about being a kind of general expert? What's that?
So
What?
A general expert.
General expert? I don't know what that means, Your Honor.
Sure.
I guess that's why she's asking the question.
Right.
Why is it that you choose to have minimal information about the case?
I have minimal information because as an expert, I am not here to diagnose domestic violence, and I'm not here to prove guilt or innocent. I am expert. I'm a social scientist on intimate partner violence, and that's all I can offer the court.
Are you getting paid to testify today?
Yes,
How much are you being paid?
$250 per hour.
Maybe you should testify in the Karen Reed trial. That was $2,500 an hour.
And was your testimony today based on your education experience working with domestic violence survivors?
Yes.
Of course, indulgence for a moment.
Sure.
Look what I got. We got pickle.
Let me ask you this. Hypothetically, if a survivor gives full custody of her children to the perpetrator's mother, can that in some way be used to exert some form of power control over a perpetrator?
Your Honor,
I mean, over a survivor.
I'm sorry. I object to this kind of using evidence and posing it as a hypothetical to specifically ask her opinion of that specific conduct.
Understood. Overruled. Go ahead.
You can rephrase?
Yes.
Hypothetically, if a survivor gives full custody of her children to a perpetrator's mother, can that be used in some way to exert some form of power control over that survivor?
Yes.
How?
So if the perpetrator's parents now have the children, they have control of the children. They make choices for the children, and that leaves the survivor powerless in that situation unless the survivor navigates to comply with the current guardian's requests, the current guardian's recommendations. It could lead to an imbalance of power from that parent. So yes, that can be definitely a form of exerting power and control.
Course indulgence.
Sure.
Careful. Thank you. No further questions.
Thank you.
Thank
Mr.
you.
Samuel, questions for this witness?
I don't want to mess up my other ankle.
Good morning. Good afternoon, Ms. James.
Good afternoon.
Not doctor yet, right?
Almost.
Almost. When will you be doctor?
May of 2026.
You and I met only once before, right?
Yes.
A couple weeks ago. In this courtroom, right?
Yes, about a week ago.
I'm going to ask you some of the same questions as Ms. Hilton. First of all, you actually worked at the Fulton County DA's office for quite some time, right?
Yes.
How many years were you working there?
I started work in July of 2019 and I left in January of 2023.
He's going to show that she's biased.
Okay, so 4-ish years.
Yes.
Okay. And did you work with Ms. Hilton during that time?
Yes.
With Mr. Fawcett or Mr. Wilson?
No.
Okay. How many times have you worked with Ms. Hilton in a case?
So in the victim advocate role, we are assigned certain courtrooms. So I would only work with Ms. Simone if she was doing a case, if she was assigned to that courtroom or a case to that courtroom. And also she was the deputy, what we would call the deputy district attorney for the domestic violence unit. So she had minimal interaction with the bulk of the cases.
Asking you for a number somewhere between X and Y.
I don't really,
Okay,
I can't really define a number. Yeah.
That's not a problem. How many times have you testified as an expert in one of her cases?
I believe once.
Okay. Of the 47 times that you testified in Georgia, were they always for Fulton County?
No.
Percentage wise?
If we're looking at a percentage, most, I would say maybe 95%.
We're Fulton County.
We're Fulton County.
All right, so 95% of 47 would be, I don't know, 45, something like that?
But also one of those cases was with the defense.
Okay. So there was only one occasion where you ever testified for the defense?
In Fulton County.
Okay. And all the other times you were testifying either for Fulton County or, I don't know, DeKalb, Gwinnett, Cobb, somewhere, correct?
Rephrase.
Well, I was just trying to do the arithmetic, but you said 47 times. One time you testified for the defense. The other, whatever, 44, 45 times you testified for the prosecution, and almost all in Fulton County.
Yes.
Okay. And so you're being paid now to be an expert instead of being a member of their staff and just coming in and testifying. They, meaning the prosecutors. Now you went out on your own and you get to bill for your time, correct?
Yes.
Okay. And do you bill for all your time or just when you're sitting in the chair?
I bill for all my time.
Okay. So when we're late starting court in the morning and you have to sit out there, you bill $250 for that too?
Yes.
Yep.
Okay. We'll have to remember that, Your Honor.
All right.
Do you know how much you've been paid, how much you've billed in this case, or how much your hourly has been in this case so far?
Not yet.
Well, I know you haven't finished yet, but estimate the amount of hours you've put into preparing to testify in this case.
I would say estimate of 3 or 4.
Okay. And you met with Ms. Hilton, obviously, correct?
Yes.
She reviewed the questions she was going to ask you.
Yes.
She reviewed the hypotheticals she was going to ask you.
Yes.
She told you, I'm going to ask you in particular about isolation, and she said, I'm going to ask you in particular about the family, you know, having custody of the children, right?
Yes.
Okay. And you told her what your answers were going to be when she asked you those questions, right?
Yes.
Okay. Did she ask you any questions, I'm curious, in preparing that you said, no, I'm not going to be able to help you?
Don't go there. Watch your steps, sir. You're getting dangerous.
On that.
No.
Okay. So she would say, I'm going to ask you X and Y and Z and A and B. And you said, yeah, I can help you with all those things.
Yes.
Okay. I'm going to ask you a few different times and in a few different ways about your knowledge of the facts of this case. Before I do that, I'll probably end just like Ms. Hilton did with that. Your testimony, in essence, is an opinion based on a lot of experience in teaching and meeting with people and reading about the characteristics of abusive relationships, correct?
Yes.
Okay. You said, I wrote it down, that you can't put abusers in a box. I'm not talking about punishment, I'm talking about, one size fits all doesn't work, does it?
Yes.
That's correct, right?
Yes.
Okay, I asked a negative. That if you looked at did you say thousands maybe, or hundreds of abusive relationships you've looked at, more than just, a little bit, they're all different, right?
Yes.
Okay. Every relationship is unique, right?
Yes.
Mandy, we need some longevity in this. We do. Mandy, I'm going to share that. Mandy, or should I say Tinkitude? This is bad. Y'all, personal joke. She sent me this in Discord, but boo, why would I want a Vienna when I have it? Why would I want a Vienna when I got the whole pickle? It's a long joke from yesterday, y'all.
The abusers.
Love it. Love it.
And I'll just say the partners, whether they're gay, or lesbian, or trans, or male, female, or whatever, they can be wealthy and still have an abusive relationship.
Yes.
They can be poor, poverty-stricken, and still have an abusive relationship.
Yes.
There can be a family of history of abuse, a family history of abuse. In other words, generation to generation, correct?
Yes.
Sometimes you'll see partners for whom both sets of parents were in fact abusive, right?
Yes.
But sometimes you'll see partners for whom the parents, there's no evidence of any history of abuse in the generation above the one that you're looking at, right?
Yes.
Some parents, again, I'm talking parents of the partners, are abusive to each other, right?
Yes.
Some parents are abusive to their children, correct?
Yes.
Including the people you look at who then become the partners in the abusive relationship.
Rephrase.
Okay, I've got two generations here. I got the generation above the partners being, however you want to characterize them, whether man, woman, or whatever, abuser and what was the other word? Driver, you said? What was you said instead of victim, we call them?
Survivors.
Survivor, and so I'm looking at the generation above. Sometimes they're abusive to each other, right?
Yes.
And both the abuser and the survivor may think of their parents and think, this is normal. This is how I was brought up in my family, and justify it in their head, correct?
Yes.
And so what I was asking then was, is it sometimes the case that the parents of either the abuser or the survivor are abusive to that person?
Yes.
So abuse isn't always just limited to same generation, if you will.
No.
You can be abusive to your children, whether your children are adults or teenagers, or you can be abusive to your grandparents, right?
Yes.
Where are you going with this?
Some parents spank their children, some parents don't spank their children, right?
Yes.
We wouldn't call that abuse unless it went overboard, correct?
I can't define that in this context.
Okay, not a problem.
Yeah.
Yeah, I like how she
I
said,
guess some
yeah.
parents are guilty of crimes, right? Parents of the partners you're looking at.
Yes.
You ever had a case, or do you have any experience in a case where the partners, the alleged abuser and the alleged survivor, the people you're looking at, that one of them is the child of a serial murderer?
No.
Would that be unusual?
I can't answer that in this context.
I'm sorry.
I can't answer that
Would
for
that-
you. I'm sorry.
Would that fit the dynamic that you're looking at, or would that be kind of outside the wheel and have to try to figure out what's going on there?
It sounds like out of the scope.
Yeah. Some people run away from home at a young age, teenagers, right?
Yes.
Some people marry at a very young age, 16, 17 years old, right?
Yes.
Some people don't. Some people get married late in life, right?
Yes.
Some people are suffering from PTSD, perhaps veterans, right?
In general, yes. It's a diagnosis.
Yeah. And PTSD can be caused by a variety of things, correct? Not just being in Afghanistan, but maybe from your upbringing, correct?
I'm hesitating to answer that because I don't practice. I don't do clinical practice in Georgia. I'm not licensed in Georgia to do clinical. I'm only licensed in Florida. That's why I'm hesitating to kind of answer that, because I don't want to be unethical in the state of Georgia when it comes to like diagnoses and mental health and a DSM-5.
Let me put you at ease a little bit. I'm not going to ask you for a diagnosis today. You're not going to be sued for malpractice for any means.
I don't want to.
Just in general, I'm not a doctor either. You know, PTSD can be the result of all kinds of different kinds of trauma, correct?
Yes.
Post-traumatic, right?
Yes.
It could be something that happened in your childhood. It could be something that happened when you were a teenager. It could be something that happened when you were in the military, right?
Yes.
All those things can create PTSD. Is PTSD something that you see in your experience being part of the dynamic, the wheel, if you will?
No.
Okay. You don't see people who are suffering from mental health problems?
So.
Yeah, I really struggle with that, June. I really don't like when people sit there and just assume that if you've been a vet and you've been Afghanistan, Iraq, whatever, you're automatically going to come back with PTSD. I mean, a lot do, but I don't like the way I just don't like the way he's doing this at all. I'm with you, June. It's like saying everybody who gets in the car wreck is going to walk away with post-traumatic stress. Not everybody does. That's funny. That's funny, but you're right. Yeah, Joe, you're right. You're right. Yeah, this guy is, every day he's rubbed my nerves.
When we talk about the definition of domestic violence, we practice as it is a choice. I'm trying to make sure I stay ethical.
Yeah, sure.
We practice it as a choice, you know.
Okay.
Yeah.
I guess what I'm asking is, I apologize if my question was lousy, but either
No, you're
the
not.
abuser or the survivor might be suffering from mental health issues, correct?
Possibly.
Okay. If you look for the root cause of abuse, it might be, for example, infidelity.
The root cause, what we study is under the definition is exertion of power and control.
I didn't pre-read this. Hey, got an idea. Let's blank a PTSD label on all defense attorneys for having to defend the worst of the worst. Hey, I like that. I love that. Oh my God. There you go, June. Love it. I absolutely love it. Jerk.
That is the abuse. But the cause, if we treat it as something that's caused by something, either you're at least close to being a doctor. I'm nowhere close to being a doctor. Something causes either the person to be the abusive partner, and something causes the survivor to be susceptible to being. I'm not asking what abuse is. We'll get to that. I'm asking what causes it.
What causes is a choice. There's no diagnosis for domestic violence. There's no root causes of domestic violence. It is one individual making a choice that they believe is right to exert power and control over their partner.
Yep.
Does the age and duration of the relationship have an impact on what would lead to abuse?
No.
There may be problems with alcohol.
Yes.
There may be problems with drug abuse.
Within the relationship, yes.
Huh?
Oh, within the relationship, yes.
And there may be other, as I said, mental health issues involved that you have to deal with in the relationship.
Personally, each individual, they may have their own.
Right. You don't believe, and I think you said this to Ms. Hilton, that all abusive relationships are the same either.
Yes, each one is unique.
Some may be more physically abusive, some may be more emotionally abusive.
Yes.
No expert would ever claim that all abusive relationships have the same characteristics or the same causes, correct?
Correct.
Your wheel, for example, that we had on the screen for a while. Remember this?
Yes.
This is demonstrative exhibit 75. I don't think we need to put it on the screen again, but I bet you've memorized this, haven't you?
Yes, it's one of my tools. So.
Yeah. How often have you used this in court?
Many times.
The wheel, each of the pie pieces, right? And the wheel looks like a pie, kind of, right?
The spokes? Yes.
Well, you call them spokes, but I'm looking at the triangles as pieces of pie. Maybe that's because I'm thinking of food. But
sure.
And each of these pieces of pie have lists of examples of how intimidation is used, how emotional abuse is used, isolation, minimizing children, privilege, economic abuse. Did Ms. Hilton review this with you and say, let's see how many of these factors we can find in our case?
No.
Have you talked to her about it before?
I spoke with her about the power and control wheel, yes.
Okay. Did she talk to you about the fact that we are not involved in this case with ruining or destroying property? Are you aware of any evidence of that?
Oh, sorry, didn't mean to do
In
that.
this case, either through hypothetical questions or what you were told by the DA's office?
No, I'm not aware of any of that.
Anything to do with abusing pets?
I'm not aware of any.
Anything dealing with displaying weapons?
No.
Are you aware of any weapons in this case at all?
No, I'm not aware.
Okay. Are you aware of anything involving humiliation or playing games or anything like that?
No.
Are you aware of anything involving controlling what you do and what you read? Anything like that? Huh?
No.
Yeah. Are you aware of anything about joking about abuse? Do you know anything about that, or any hypotheticals asked you about that?
No, I don't know
anything about shifting blame onto you?
No.
Anything about making you feel guilty about your kids?
No.
You know how old the kids are in this case?
No.
You know how old they are? You talked about a hypothetical of placing kids with the supposed abuser's parents as being a sign of control. How about if the kids are like 6 months old and they're placed with the man's parents?
I have no knowledge of how old the kids are in this case.
Any evidence of using a 6-month-old or a 1-year-old to relay messages?
No,
Using visitation?
no,
I'm kind of going through your wheel, but you know that, right? Any evidence of treating the person like a servant,
no,
being the one to define gender roles,
no,
using race, culture, religion, or citizenship against one another?
no,
Preventing anybody from getting a job?
no,
Are you aware that Ms. Wolfenbarger was working at Waffle House?
no. I don't know.
You were asked about isolation. Would you describe isolation as having an outside job, having friends, having your sister working with you? Is that isolation?
Depending on depending on what the domestic violence looks like I said, every relationship is unique. Isolation doesn't fit in a box where it has to be one thing.
Right, but if the point of isolation is to prevent you from having, recourse to friends or communities, I think you said committees or whatever it is, you have a sister, you have a job, you have coworkers, that's not isolation, is it?
It could be for some relationships. I don't know any examples of that.
Okay.
I haven't interviewed anyone in this case.
Yeah, I mean, the problem with hypotheticals is if you add a few more facts, they get more and more confusing, right?
No.
Well, I just gave you more facts dealing with isolation. You said, well, I just don't know about that.
It wasn't confusing. I said that I haven't interviewed anyone in the case. I just can't speak to that.
Well,
I have to, guys. I have to. I have to. I have to. We're going to go code red. He's pushed me to code red. I am at code red. Guard your ears and your eyes in 3, 2, 1, go. She is snapping him down. I really appreciate her. This woman is a good witness. This woman is not letting him run on over her. She is standing her ground. I love it. He's way too demonstrative for his physical appearance to be. He's not Jackson or LSC.
I'm not asking about your experience. I'm asking about your expertise. Would you describe that as
Love
being
your
isolation?
humor.
It all depends on the nature of the relationship. Isolation isn't just one thing. I haven't interviewed anyone, so I can't answer that question.
Okay. The cycle of abuse, which is Exhibit 79, have you heard any evidence of a breakdown in communication? This is the tension building, number one. You heard any evidence about that or any hypotheticals about that?
No.
Have you heard any evidence of blaming, threats, intimidation, number two?
No.
Number three, abuser apologizes. Any evidence of that in this case that you know of?
No.
Gives excuses, blames the victim, denies abuse, anything like that?
No.
The fourth stage, calm. Any evidence of any of that in this case?
I don't have any evidence of this case. I haven't read any police reports. I haven't interviewed anyone. I'm not here for guilt or innocent. I'm just giving the science of what these tools mean and answering the hypotheticals as I'm asked.
Would you agree with me that many people who commit the crime of murder are not involved in an abusive relationship?
I can't answer that question because I don't know. I don't know.
You are aware from your experience that many people who are in an abusive
Okay, it kind of looks like to me like he's lost a lot of weight and he's not fitting in his clothes. That's what it looks like to me. Maybe he's a bachelor. He lost his wife. He doesn't know how to iron. I don't know. But he's a freaking lawyer. He needs to pay for proper cleaning and proper garments.
relationship don't commit murder.
Yes.
I know you say you know none of the facts in this case, but you know some by virtue of the fact of the hypotheticals that Ms. Hilton said, these are the ones I'm going to use. Do these work? You know, can we use these, right? So you know from her preparing you that these are going to be the facts of the case. She wouldn't be asking you about something totally irrelevant, would she?
No.
I'm just trying to help the dude out.
Did you tell
Yeah,
her to
me too.
change any of the hypotheticals to make them? Okay.
No.
Fine, good enough.
Oh.
I think you said you have no opinion whatsoever about this case, right?
I was called to do the science. I can't diagnose domestic violence. I can't do guilt or innocent. I'm not, I'm not a prosecutor or someone of the court.
I mean, I understand that, and I appreciate it. The point is that your testimony is just general observations about the way lots of different relationships that are bad exist, right?
No.
I use too many words that aren't appropriate, right? There are abusive relationships involving power and control. Your testimony focuses on that, but you don't know anything about this case, right?
No.
Correct?
Correct.
Okay. And as Ms. Hilton said, you haven't read a single police report, right?
No.
If I ask, it's the problem with a negative question. That's correct, right? You haven't read a police report.
No, I haven't read a police report.
All right. These jurors have heard, I don't know, a dozen witnesses. You didn't hear any witnesses at all, correct?
No.
You've not talked to the detectives in this case?
No.
Or the medical examiners?
No.
Family members of the people involved?
No.
Either the defendant or Ms. Melissa Wolfenbarger, correct?
No, I'm not an investigator. No.
Right. You haven't talked to her. Have you learned anything about her parents and her family and her upbringing?
No.
Even from watching a little TV or learning a little bit about the case?
No.
No idea?
I have no idea.
Okay. All right. You haven't talked to me about this case, right?
No.
We had one brief court appearance together last week, but other than that, you and I don't know each other at all, right?
No.
Okay. Those are all the questions I had.
Ms. Hilton, anything else?
Now, Mr. Samuel asked about different parts of the cycle of abuse. Could arguing be something that occurs in the tension building phase?
Yes.
Loud arguing, could that be something in the tension building phase?
Yes.
What about dragging of hair? Could that be something that be in the physical abuse or incident part of the cycle of abuse?
Yes.
What about dragging someone up the street? Could that be a part of the incident phase of cycle of abuse?
Yes.
Okay. What about markings on necks consistent with strangulation? Could that be evidence of an incident of
Yes.
abuse? Could a victim or survivor who drops a TPO after a private meeting with a perpetrator be examples of what can happen in the reconciliation phase?
Yes.
Can a survivor, who after meeting with her abuser privately decides to give full custody and control over her child something that can happen in the reconciliation phase.
Yes.
And give full custody of her child to the abuser's mother. Could that be something that happens in the reconciliation phase?
Yes.
If a survivor after an alleged abusive incident, once she called the police, goes back to the abuser, could that be something that happens in the reconciliation phase?
Yes.
And are those some examples of what you've seen about how the cycle of abuse can occur in a domestic violence relationship?
Yes.
I have no further questions.
Thank you, Mr. Samuel.
No, thank you.
Okay, thank you, ma'am. You may be excused. You can step down.
Thank you.
Okay, ladies and gentlemen, it's about 3:05. We're going to take an afternoon break and probably 15 minutes, maybe 20. And we'll be back in here at 3:25. Realistically, it's going to be closer to 3:30. You know how that works. You've developed an understanding of court time now. Thank you for your understanding. We are in recess and we'll get you back.
So here we are. The bottom line is, what was the impression that the jury got from his testimony? It's crazy when our opinions vary from jury opinions. And we should be live by now. And this is live. So what we do have is we will be going over to this. We're going to watch some of their testimony. We've been kind of catching up a little bit on the we've been trying to catch up a little bit on the Charles Adelson trial. This is Wendy's testimony. What qualifies you to talk about human trafficking? You know, it really irks me when people read one or two books and they think they're freaking expert. You're a lawyer, but where's human trafficking for you in this? How does human trafficking have anything to do with you? I hate it when people use human trafficking as a platform when they don't even have a platform. How and what do you freaking know about human trafficking? How and what do you know about human trafficking, woman? So you studied up online? You read other people's books and you just regurgitated their shit? Excuse my French, but there are so many human trafficking survivors out there who are sick and tired of goody two-shoe little rich lawyer biatches who think they have the right knowledge and understanding to write a book on human trafficking. And yes, I'm getting on my soapbox. I need a pickle break. I need my pickle. I have to do it. It drives me crazy. Stop. Thank you. So that makes you better because you wrote a book on human trafficking? Please. Oh, it was fiction. You should know your book inside and out, Biatch. If you wrote this book, you would know the answer to this. Come on, please. Do y'all not have sound? I'm pretty loud. Oh, come on, Leroy. Come on, Leroy. Frankie. I think if you don't have sound, let me know. I don't know why there's no sound. It's screaming on my end. I have it on max. Let me play something. Hold on. It's playing sound. I hear you. I see you. Give me a second, booze. Come on now. I'm going to go to 509. Let me refresh the page. Now do we have sound? Now? You hear me? Okay, now can you have sound? No court sound. Okay, let me go to court TV over here. Let me pull up another trial and see if we have sound over here. Do you have sound? Sound? Now? Are you hearing this court? Okay, let me see something. Now? 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 Y'all stay there. I'm going to reboot. I'll be right back. Do not go anywhere, please. I'm going to reboot my page. Hello, I'm back. Let's see if this worked. I don't know why this went that way, but it did. Now let me see if you have.
These are factors or tactics you may not see when you approach a survivor of domestic violence. You may not see intimidation. Mind you, these are all inside.
Now?
You may not see someone being afraid of the book. You may not see someone abusing pets or using weapons as threats, right? Putting a gun on the table.
I need a response.
You may not see the emotional abuse.
Yes?
You may not see that person being put down. You may not see the humiliation, or you may not even think.
Okay, so we'll go back to Wendy Adelson.
Prosecutor giving her a strong warning not to lie.
That's interesting because I didn't have my hands on the clock. My hands weren't anywhere near the keyboard. They were right here. Oy vey. Anyway, we need to be looking at the clock because they should be coming back any minute.
Saying we've got the evidence. And wait, let's just back the truck up for a minute here. Wendy Adelson is the lawyer of the Adelson family and just said under oath that she never reviewed her dentist brother's indictment. We're going to hit a break. Don't go anywhere. There's much more to come from the prosecution right after this.
A brilliant law professor gunned down
In the midst of a bitter custody battle.
Now the victim on court.
I mean, somebody hired him, right? Not necessarily. Somebody paid him. I learned something this morning. Yeah, me too. You didn't want him held accountable if it was your family members. Didn't you tell law enforcement that? That's not what I told law enforcement. What did you tell law enforcement? I told them that the person who did this should be held responsible and that I had nothing to do with it. Page 122, lines 7 through 12. If somebody tried to kill my ex-husband, they should be prosecuted to the full extent of the law. The investigator says regardless of who it is, and your answer is, I mean, it would be different if I thought it were my brother. But I don't think it was my family. It's different now, isn't it? No, it's not different. That's exactly
different
what
today,
I said
isn't
right
it?
here. No, that's not
No
right.
further questions.
Welcome back. Let's go back to court together now. There's more from the prosecution for Wendy Adelson.
As denied as to improper impeachment is sustained. The jury is disregarding the last comment from the prosecutor. Go ahead.
Didn't you just say that you weren't on OkCupid at the time that you were dating Jeffrey Lacoste?
I don't know when we say I officially stopped dating Jeff Lacasse, but there's a chance that, I mean, I don't remember in 2014 whether I had gotten the app and started talking to people before we officially broke up.
Okay, so my point is there's a chance that he was right. You were being unfaithful or at least talking to other people. He had a reason to be jealous.
I think he had some serious jealousy issues that may or may not have been founded.
Yeah, I think we got from your testimony that you believe he had serious jealousy issues. My question to you is, did he have a reason to be?
No.
So he was wrong.
He was wrong in June when he accused me of being with multiple people that I wasn't with. Yes.
Okay. What was wrong with Dan's mother trying to make arrangements for the kids in the event of your arrest? Wasn't that a kind thing to do?
I don't think it's kind to put my children in foster care.
Wasn't the foster care intended only to cover the time frame that it would take for her to get on a plane and get here?
She never said that.
You thought she was just going to leave them in foster care?
I don't know what to think. They have a mother. They don't need to be in foster care.
But they wouldn't have a mother in the event of your arrest, Ms. Adelson. Wasn't that the...
Okay, June, this is the feed that I have, and it is, of course, Court TV. So they may be a minute behind. They usually are a minute behind.
Deputy, and raise your right hand to swear you in, okay? Okay.
Now, when you raise your hand, please, you solemnly swear to testimony about the course of I do. Dr. Denise, take a seat, state and spell your name for the record, please.
I was going to go, he got the assignment as far as appropriate dress, but I think that's a she.
Oh, sorry.
It is.
Dr. Carol, Carol, Terry, Terry.
Dr. Terry, good afternoon.
Good afternoon.
Can you tell the court where you're currently employed?
Well, I am currently employed as the Chief Medical Examiner for Gwinnett County.
Okay. And what are your duties as a chief medical examiner?
Well, I am a forensic pathologist, and my duties involve investigating deaths that are reportable to my office under the Georgia Death Investigation Act. So these are deaths that are sudden, unexpected, unexplained, or due to non-natural causes. And as the medical examiner, my duties involve determining cause and manner of death. Cause of death is what it sounds like, what caused the person to die at this point in time. Manner of death is a way in which we categorize deaths for purposes of reporting on the death certificate.
Okay. And where did you work prior to being employed at Gwinnett County?
Prior to coming to work at Gwinnett County, I worked as an independent contractor for Dr. Gerald T. Gowitt, and that's G-O-W-I-T-T, who is the chief medical examiner for DeKalb County. And not only did we handle cases for DeKalb County, but we also covered medical examiner cases for Hall, Henry, Rockdale, and White counties.
Okay. And prior to that, where did you work?
Prior to that, I worked at the Fulton County Medical Examiner's Office as an associate medical examiner.
Okay. And are you licensed to practice medicine in the state of Georgia?
Yes, I am.
And when did you become licensed?
1992.
Can you go over for the jury your education and training?
Yes, I can. In 1986, I graduated from Emory College of Emory University in 3 years with a double major. I have a Bachelor of Arts in Religion and a Bachelor of Science in Biology. From 1986 to 1990, I attended Emory University School of Medicine, where I received my Doctor of Medicine degree.
Hang on, I'm so sorry to interrupt you. I'm just going to ask if you'd slow down a little bit.
Okay.
I want to make sure the court reporter can keep up and you're a little bit of a fast talker.
Oh, sorry.
Thank you. That's okay. Please go ahead.
Thank you. So I am a medical doctor. From 1990 to 1995, I did a residency in pathology in the Emory University affiliated hospital system. Pathology, broadly stated, is the study of disease. And my 5-year residency involved a combined program of anatomic and clinical pathology. Anatomic pathology is tissue-based pathology and involves diagnosing disease states from tissues, such as biopsies, organs, or tissues removed from living people, as well as autopsy specimens. Clinical pathology is the laboratory medicine aspect of pathology and involves such areas as chemistry, hematology, microbiology, and blood banking. During the last year of my 5-year residency, I was allowed to work exclusively at the Fulton County Medical Examiner's Office in a subspecialty of pathology, forensic pathology. And forensic pathology is the medical legal investigation of death. So after the completion of my residency in 1995, I did an additional year of study in forensic pathology, also at the Fulton County Medical Examiner's Office. And this year of training outside of the residency was referred to as a fellowship year. And I did my fellowship year at the Fulton County Medical Examiner's Office in forensic pathology from 1995 to 1996. But because I already had a year of experience in that office, I was essentially treated like a junior attending and got to supervise other individuals in training as they rotated through the office. Following the completion of my fellowship in 1996, I stayed on staff at the Fulton County Medical Examiner's Office as an associate medical examiner. And that's where we picked up. I worked at the Fulton County Medical Examiner's Office from 1996 to 2004. 2004, I went to work for Dr. Gowett in DeKalb as an independent contractor and worked for him until the beginning of 2006. In February of 2006, I was awarded the medical examiner contract in Gwinnett County and took over doing the medical examiner duties for Gwinnett County. In Gwinnett County, the medical examiner position is not a county department, it is a contracted position. And my contract comes up for renewal every 5 years, where I have to rebid for the contract. And as I said, I was awarded that in February of 2006 and have maintained it to the current time. As we said, I'm licensed to practice medicine in the state of Georgia and have been since 1992. I am triple board certified by the American Board of Pathology in all 3 areas of pathology in which I have trained and studied: anatomic, clinical, and forensic pathology. I have personally performed between 6,800 and 6,900 autopsies. I've supervised individuals in training in approximately 700 additional cases. In my career, I have examined over 10,000 bodies because not everybody gets an autopsy. There's some bodies that I just do an external examination on and maybe draw specimens from to do additional testing, such as drug screen or other types of laboratory tests. And I have been tendered as an expert witness in the Superior Courts of Georgia over 455 times.
Your Honor, this time the state will move to tender Dr. Carol Terry as an expert in forensic pathology.
I am afraid to object, Your Honor.
Go ahead.
Good.
Now, can you tell the jury what an autopsy is?
Okay. An autopsy is a medical procedure by which a body is examined, both externally or from the outside as well as internally, looking at the organs to evaluate the extent of disease and or injury.
And who or what factors determine whether or not an autopsy is performed?
Well, as I said, for us as medical examiners, it's dictated by state law, which cases are reported to the medical examiner's office. And again, these are deaths that are sudden, unexpected, unexplained, or due to non-natural causes. And then Once it's reported to the medical examiner's office, it is left up to the discretion of the medical examiner what type of an examination is conducted, again, with the goal to determine a cause and manner of death for purposes of reporting on the death certificate.
Okay. And the procedures that you've testified to, are they generally accepted in the medical community?
Yes.
And you tell the jury, you familiar with Dr. Joseph Parker?
John?
John Parker, excuse me.
Yes, I am.
And who is Dr. John Parker?
Dr. Parker was a mentor of mine. He worked at the Fulton County Medical Examiner's Office and also in Bibb County as the medical examiner in that area. He was responsible for some of my training. And ultimately, when I went to DeKalb County to work for Dr. Gowett, it was because Dr. Parker had stepped down from that position. Dr. Parker, I worked with him in the Fulton County Medical Examiner's Office when I came on staff there. I think and thought the world of Dr. Parker. He passed away in 2012.
Okay. And was he the medical examiner that was, I guess, the head medical examiner that examined the remains of Melissa Wolfenbarger when they first came in?
Yes, he was the medical examiner who was on duty the day that the remains of Miss Wolfenbarger were discovered.
Okay. And at any point, did you assist in any type of investigation or analysis as it relates to the remains of Melissa Wolfenbarger?
Yes, I did.
Okay. And what period of time are we talking about where you would have been involved in any type of analysis regarding those remains?
My first direct interaction with the remains occurred in February of 2000 when I was turning over the skull along with some other skulls to the state's forensic artist, Marla Lawson, to do some facial reconstructions. I had a case of mine from 1998 that I wanted her to do a facial reconstruction on, and she had recently completed some training. Her skills as a forensic artist were legendary in the police department, but she had adopted or had taken on some new training in doing facial reconstructions off of the skulls using clay or paper mache. And so that's when I made her acquaintance in February of 2000. She came to my office to get the skull of the case I was handling, but she said, if you have any others that you want reconstructions on, she said, I'll bring a U-Haul if I have to, give me all that you have. And she, was taking on that work, and I had amassed the reports associated with these different cases, as well as investigation summaries, and was turning them over to her. And when she looked at this particular skull, she raised the question of the sex of the skull, because it was indicated to be a white male. And Marla, if you knew her, she was very modest, even though, exquisitely talented, and said, this looks like a female to me.
All right.
Sustained.
All right. Let me ask you this. At that time in Fulton County, were you working with investigator Tina Miller?
She was a detective with the Atlanta Police Department, yes.
Okay. Did she also assist the Fulton County Medical Examiner's Office with investigations related to missing persons and/or death investigations?
Not death investigations, missing persons, and unidentified remains.
Okay. Were you aware whether or not Detective Miller went out to that location where Melissa's Wolfenbarger's remains were located at any point during the investigation?
Yes, she did.
Okay. And you familiar with the location being Avon Avenue in Atlanta, Georgia?
Yes, I am.
And is that in Fulton County?
Yes, it is.
Tell the jury what happens when, say, a body or remains come into the medical examiner's office.
Well, when the body comes into the medical examiner's office, the medical examiner on duty determines what kind of examination is going to be conducted on the remains. And then depending upon the case, that dictates what is done. Most of the time, the bodies are intact. And again, they may get what's called an external examination, just an outside viewing of the body and drawing of specimens for additional testing. or they may get an autopsy where the body is opened. And there may be a complete autopsy. In Fulton County at that time, we did not do limited dissections. We only did complete autopsies. So if an autopsy is done, it involves opening up the body and examining and removing the brain as well as the organs of the chest and abdomen and pelvis. And in the course of the examination, specimens are collected for potential additional testing. Again, it depends upon the nature of the case.
Okay. And are any observations or conclusions, are they documented in any form during that process of performing the autopsy?
Yes, typically the examinations are documented with written notes and or dictations that are then converted into a final report.
And is there other forms of documenting the process of the autopsy itself?
Yes, also photographs are taken typically in the course of the examination.
Okay. At the conclusion of the autopsy, is there a process for reviewing or discussing observations that are made during the autopsy?
I don't know necessarily if at the conclusion of the examination, but in the Fulton County office, as we were associated with the training program through Emory, we routinely had teaching conferences and conferences where we would sit and review all of the slides that were taken, because at that point in time, things were done with 35 millimeter and slides were created. And every week we would have one or two conferences where we would go through all of the slides.
Okay. Now, in preparation for your testimony today, did you review any documents and or photographs associated with the autopsy of Melissa Wolfenbarger?
Yes, I did.
And what did you review?
Well, I reviewed, it turns out I had case notes that I had collected back at the time when I did this, when I was doing this review of the case, because I was very much interested in trying to identify remains. So I had copies of notes from the file, including some of the notes that I had made documenting some of the actions I had taken to try to get the remains identified. I also reviewed Dr. Parker's report. I reviewed any investigative reports that were in the file, as well as any photographs that were provided to me, because I did not have actual photographs from the examination.
Okay. And at any point during your work that you did associated with this case in particular, did you have an opportunity to either review any of the remains of Melissa Wolfenbarger? And you could describe that for the jury.
Yes, I did.
And when did you do that?
Well, in February of 2000, when I was turning the skull over to Marla, that was my first time that I had an opportunity to look at the skull.
Oh, okay.
And I looked at the skull.
All right. And discuss any other opportunities that you've had to look at the remains of Melissa Wolfenbarger.
And after she was identified, I had the opportunity to go and retrieve some of the specimens that had been collected to follow up on requests made by the Atlanta Police Department's Detective Calhoun to submit specimens to the Georgia Bureau of Investigation, specifically for some drug testing.
Okay. And when you say specimens, are you referring to the extremities of remains that were located?
It was some soft tissue from the extremities, yes.
Okay. All right. Now, what, in terms of, initially, I believe your testimony that there was a process of conducting an identification. What did you do to identify the remains?
Okay. And then two, I've also neglected to mention, also in the course of doing this, there were times when I went back to the remains, specifically the skull, to extract teeth or to take additional bone to submit for potential DNA analysis. So that was something else I also undertook with the knowledge of Dr. Parker to try to facilitate the identification. So what else I did in addition to collecting and submitting specimens for DNA analysis was, again, just became aware of features associated with the skull. For example, I did not need my records to refresh my memory that the skull had one filling in tooth number 31. That's something I've remembered all these years. There was one filling in that tooth. And that was something I was aware of as I was checking records and any cases came to my attention. Also, at this point in time when I was in Fulton County, I did have an interest in trying to identify unidentified remains. And I had a computer program where I took missing persons reports and locations of where people went missing and plotted them on this map along with where we had unidentified remains, trying to look and see if there's any kind of spatial relationship between where people have gone missing and where remains were found. So this is something is just about being aware of who's missing and who we have who are unidentified in our morgue. Some people have various other research interests. This was something I was very much interested in because as a forensic pathologist, one of our big goals is to answer questions. And to me, there's no bigger question than who somebody is. And that was something that was of interest to me. And so I was happy to do whatever I could to try to facilitate the identification in this case. And especially since Dr. Parker was kind of part-time with our office, so he wasn't always there. But this was something that was always on my mind.
Okay. And what was the process for identifying the skull that was retrieved in April of 1999?
Or how the skull came to be identified?
That's correct, yes.
Okay, because we had made attempts to have DNA pulled from the skull from the teeth.
Objection. Reapproach.
Sure.
Sidebar. Sidebar. I forgot that I had to pay a water bill today. Let's see if I can log in. Nope, that ain't the passcode. I hate these kind of. I gotta fight with the passcode on that. Let me get this zoomed. Oh, we are zoomed. It's not real. What's not real? Thanks for announcing it. Just kidding. Go get squeaky clean. If we can't hear you squeak, you're not clean. Ah ha 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 ha. Nope. It's so I forgot password, so I have to redo my password.
And as far as the, was the Fulton County Medical Examiner's Office able to retrieve any dental records associated with this case itself?
Yes.
All right. Did you have an opportunity to review those records along with Dr. Hopple?
Yes.
And was that the basis for the determination of the identification of the skull?
Yes.
Okay. All right. Now, I'm going to hand you.
I'm in. I'm in like Flynn. We good. It paid. Yay!
Your Honor, the court's permission, I'm going to hand Dr. Terry the following exhibits I'm going to read into the record.
Yes, sir.
Exhibits 34, 36, exhibits 40 through 49, Exhibits 51 through 52, Exhibit 54, Exhibit 56 through 57, and Exhibits 60 through 61. All right. Terry, I'm going to hand you.
Hang on just one second. Sure. You want to come here, please?
Yay! Got it all paid. Whoop, 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 whoop.
Go ahead, Mr. Fossett.
You could work with here, you could look at them.
Yep. All done, folks. Oh, so she's got to go through these. I like the fact that she's being very methodical. She's really looking at them. She isn't doing this and saying, yeah. She's making sure that there's nothing in there that's not supposed to be. I like her. Yeah, you're going to be at the Adelson trial? It's weird not being able to feel any vibration when I talk. She's taking her sweet time about it, y'all. Very sweet time about it. I would have thought she'd be done by now. But how many years ago was this? I would want to read every little word myself. That's when I would ask for them to feed me the information before I even went. I wonder if she reviewed a record. Yeah, that is so true for a lot of us, Joe Schmo. It's the same password for everything. Everything. Fair enough.
Okay.
Okay. And after viewing those photographs, do you recognize those images as being associated with the remains of Melissa Wolfenbarger?
Yes, I do.
Do you recognize those images as being associated with the same remains that you viewed at the Fulton County Medical Examiner's Office in 2000?
Well, this doesn't specifically show the skull. Those are the remains I remember actually seeing, but I am certainly familiar with the photographs.
Okay. And are they a fair and accurate representation of what you recall observing?
Yes.
Your Honor, this time the state will move to tender into evidence. States Exhibit 34, 36, 40 through 49, 51, 52, 54, 56 through 57, and 60 through 61.
Mr. McDermott?
No objection.
Okay. They are admitted.
Now, what was your recollection after reviewing the documents as to when each of the skull and extremities were located?
Well, the skull was located on April 29th of 1999, and the extremities were located June, let me double check here. I can't remember the 2nd or 3rd, also of 1999. So let me find this. June 3rd, 1999.
Mr. Fawcett,
Yes.
are you preparing to publish those photographs?
No, I'm not.
Okay, just
No, I'm not.
making sure we have a heads up before we do.
Absolutely, Judge. I am publishing State's Exhibit 2. So I want to turn your attention to this State's Exhibit. Is that area in itself familiar to you?
Just by virtue of the names, I don't recall ever having been out there myself.
And you recognize that as being the location where the skull and the extremities of Melissa Wolfenbarger were
Well, I
located?
object, Your Honor. She says she didn't have any knowledge, personal knowledge in this area.
I'm not sure that's exactly what she said, but overruled. Go ahead.
You recognize that location, the street itself, as being the location where the remains, the skull, and the extremities of Melissa Wolfenbarger were located?
Yes, as I said, I'm familiar with the names, but I can't say that I directly went to that location, but I in my mind, had the skull associated with Avon Avenue.
Okay. And looking at that photograph, based on your review of your notes and your recollection, the image depicted in State's Exhibit 2, is that generally the close proximity in which the remains, extremities, and the skull are located?
Yes, that is my understanding.
I do plan on publishing photographs at this point, Judge.
Okay. So ladies and gentlemen, I told you that I would give you a heads up so you could sort of prepare yourselves that we probably the next series of photographs are going to be somewhat graphic. For those of you who are in the gallery, I encourage you, if it's not something that you want to see, to make arrangements so that you don't have to see it. Go ahead, Mr. Fawcett.
Yes. Now, Dr. Terry, you were testifying as to your, I guess, ability to review and examine the skull of Melissa Wolfenbarger?
Yes.
Okay. And I'm publishing State's Exhibit 16. And just, could you describe the state of the skull that it was in when you viewed it?
All right, in this photograph, this is a decomposing head that was in the roadway. This is the head that I saw the skull from when I mentioned that I was turning the skull over for reconstruction purposes. But again, this is a photograph I'm familiar with as it pertains to the day that the head was found in the road there at Avon Avenue on April 29th, 1999.
Okay. And after viewing the skull, were you able to determine if there was any damage to it?
Yes, there was damage to the skull.
And what type of damage are you referring to?
On the left side of the skull, there were some fractures, and there was some bone in the roadway that were described in the report, as well as in an adjacent plastic bag. It appeared that the skull had been struck by a vehicle in the roadway.
Okay. And what does post-mortem mean?
Post-mortem means after death.
And is there a distinction between injuries you would, I guess, damage to flesh or bone? Is there a difference between, I guess, pre and post-mortem?
Or ante-mortem, post-mortem, yes. Before death versus after death, yes, there's a difference.
And what is it? What differences would you observe?
Well, typically differences that you see in antemortem injuries, the person's alive, so they still have a blood pressure, there's blood flow. And so when an individual is injured antemortem or before death, you have bleeding that's associated with injury. Postmortem or after death, there's no longer blood flow, and these injuries don't bleed.
I'm now going to show you what's been admitted at State's Exhibit 36. Can you tell the jury what we're looking at?
Okay, yes, this is one of the vertebrae that was associated with the head that was, or the decomposing head that was found in the road on Avon. And this is one side of this. It's a cervical vertebra, or a bone that's from the neck area. And you can tell because, can I touch the screen?
You can. You can enable that function and you can actually tap on it, draw on it in colors.
Okay, let's see.
There's a button. I think it's off to
Ooh, you can draw in color. Can we play?
the left on the bottom of the screen.
Oh, okay. These structures here in this vertebra identify this as being a cervical vertebra or a bone from the spine in the area of the neck. And as we look at surfaces here of the bone, specifically those are articular surfaces where the bone would interface with adjacent vertebrae or bone. So in looking at this surface of as well as in this area here, this is where the bone would articulate or interface with the adjacent bone of the spine. And based on the review of the report, as described by Dr. Parker, this would be the third cervical vertebra. So 3 down from the base of the skull.
I'm going to show you State's Exhibit 37. I can offer no assistance with getting the marks off the screen though.
I think there's a clear button on the maybe bottom right.
There's something that says leave.
I don't think I want you to leave.
Oh.
No, ma'am.
Nope, sorry.
I might be able to assist.
Go ahead.
Yeah, hold on.
Yes.
I'm sorry to say this, and I know I'm going to catch a lot of flack for it, but that reminds me of Mrs. Doubtfire in a suit. You know, the face reminds me of Mrs. Doubtfire.
Okay, all right. Okay, so this is the flip surface of that vertebra. And in looking at this surface here, specifically, oops.
Wednesday.
Can we bring that function back up?
Wednesday. Wednesday. Wednesday.
Ah, okay.
We're lazy. Wednesday. 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 W-E-D and Wednesday.
Specifically, these areas all appear to
Wednesday.
be kind of shaved off to the same level. So, and again, this is the reverse surface of that vertebra.
Now, when you are performing autopsies or working at the medical examiner's office, do you often use instruments to assist with that?
Yes, I do.
And what types of instruments do you use to, say, cut through bone or hard
I know.
materials while you're working?
Typically, I use an oscillating or striker saw where I have a blade that will either spin or go back and forth to cut through bone. Another tool that I commonly use to cut through bone are basically
Guys, hold on. We got some movement in the other trial. The judge is coming in, probably to tell everybody to go home, but let's see what he says.
Everyone can be seated. Well, I do have some good or bad news for the rest of you, depending on your perspective. After speaking with the attorneys, we have decided you will never see your family again. Joe, you are released. Your jury service has come to a conclusion. Before I change my mind, you gotta run.
What?
Like to go back to that.
What's that?
They're released. Does that mean she's pleading guilty? No admonishment, nothing. Okay, guys, that's weird. What? Is she pleading guilty?
Everyone can be seated.
Okay, this will be funny if she pleads guilty.
Let's briefly go over the logistics of the jury selection
Oh.
tomorrow. Once again, the prospective jurors are going to have their paddles with their numbers. We are not going to use names to identify them in the open courtroom. For setting up the list at this point, although the list has been linear in terms of total number, we are going to need a list that goes from 1 to 110. Okay. Once they're placed in that order, from there, we will have some additional chairs out in front. So we're examining 21 witnesses 21 prospective jurors at any one given time. Again, the parties are to refer to the numbers when examining the witnesses, or the jurors. If need be, if you need to approach to address a matter that might involve the names of the prospective jurors for any reason, please approach to do that. Once we've gone through both parties, going through their individual voir dire examinations, we will do strikes as we would normally. We'll just retire to the jury room and do so. Are there any questions before we break for the day?
Your Honor, are they going to be randomized based on the order that they've come in already, or are they going to be in the same order?
In all likelihood, randomized, but as Joy indicated, anything concerning those. Well, with that, really, we'll have the 21 in the box. We'll probably have another 30 plus on the benches. So more or less half will be up here, half will be downstairs. Downstairs, do we have enough bailiffs to ensure no one is speaking to each other downstairs while we're waiting? Maybe the easier way is to have them all report at 11. We'll deal with the first batch. We'll put the other batch out on a break. And then if we cannot select the jury out of the first 50 or so, we'll move on to our second bench. Any other questions?
You want us here at 11, Your Honor?
Actually, you all will probably need to be here ahead of that. Please be here by 10:30. I intend on getting at least the order on the motion to suppress and the motion in limine out this evening. Concerning the calls, I did review the calls yesterday. I am going to review them again. I don't know if I'm going to have the time to do a written order, but if we need to address it at sidebar, I'll be able to give the ruling as to the calls as well before we get started. 10:30, and then at 11, we will move into the jury selection. Have a good evening.
Thank you, Your Honor.
Just go ahead and randomize it. Yeah, yeah.
Okay, so that's 9:30 my time. He was releasing those who would not be coming back tomorrow. So they've got their pool for the next phase. So maybe by tomorrow they'll have a jury seated, and Friday, the 22nd, which is what he was pretty much demanding and pushing for, the opening statements begin, and then on Monday we will be in full-blown trial. Well, they sent home everybody else. They have they've gone through the first phase of weeding through. Tomorrow they bring them back and give them the paddles, and they will go through that process tomorrow. And we should have opening arguments on Friday. That is, I think, the goal. Central time zone is going to be 10:30, East 9:30, Central 10:30, and 8:30 West Coast. There you go. All right, now we go back to Mrs. Doubtfire.
Kind of garden shear type things used to cut like small tree branches, and we'll use those on ribs to remove the chest plate. Typically, we'll use the striker saw or the oscillating saw to open the head and to take sections of bone.
Now, did you also, were there also photographs of Ms. Wolfenbarger's extremities included in the photographs itself?
Yes.
Right. And did those extremities have flesh on them?
Yes, they did.
Okay. And let me ask you this. Do you recall either through photographs or reports how the condition that the remains were found in?
Yes, I mean, they exhibited decomposition and had been dismembered or cut.
What about how the remains were stored?
There were plastic bags there. For example, with the skull, there was a plastic bag nearby, but the skull was in the roadway. And then the extremities were located in plastic bags. One set of remains, my understanding, was outside of a plastic bag.
Okay. And turning your attention back to the skull, and that's Exhibit 16. Can you tell the jury, was there any sign of insect activity on the skull itself?
Not that I saw in any of the photographs or that I saw described.
Okay. Republished in States Exhibit 16. And what does that tell you, the absence of insect activity, maggots, fly larvae on the skull of Melissa Wolfenbarger?
Given the condition of the skull, that it was somehow protected from insects getting to it, flies getting to it. So understanding that there was a plastic bag nearby, most likely it had been in that plastic bag soon before it wound up in the roadway, because otherwise flies would have been attracted to it.
Okay. So if this skull had been out for a day or a full day, you would expect to find insect activity?
yes, I would expect flies to have gotten to it and have laid eggs on it.
What is the impact of it being, say, double tied in a plastic bag? What is that impact on that?
Well, again, I don't know about double tied, but at least somehow being protected from insects getting to it. That would keep flies from being able to get to the remains and deposit eggs, and which then turn into maggots.
Okay. And does the storing of the remains in a sealed compartment like a plastic bag, does that impact any determination on the timing of death, or does that impact that at all?
Yes, I mean, it makes it harder because of the fact that it is, well, first of all, you don't know where it's stored, and it's confined in a plastic bag, which is going to interfere with decomposition and things of that nature. So it's going to make it harder.
Okay. And was your indication that the image depicted on State's Exhibit 40, a image of a leg of Melissa Wolfenbarger, was your indication that that was in a protected plastic bag as well?
It would just, again, appear to be so, because again, we don't see any insect activity exhibited by this leg. So I would say that it was somewhere where it was protected from insects getting to it.
Okay. And you testified that there was some type of, something consistent with the saw on, I guess, the neck, the vertebrae that you testified to. Is that correct?
That is correct, and that's based on my observation as well as Dr. Parker's report as well. Again, looking at those surfaces, they appear to have been cut.
And were there other extremities or parts of Melissa Wolfenbarger's remains that also appeared to have the same type of saw cutting marks on them?
Yes, there were.
Okay. I'm going to show you State's Exhibit 41. Can you tell the court what we're looking at?
State's Exhibit 41, this appears to be the right lower leg and foot.
Okay. And State's Exhibit 42. Is that the plastic bag or a photo of one of the bags that the remains were stored in?
Yes, this is a photograph of one of the plastic bags that was associated with the remains.
Is that the type of storage vessel that could prevent insects from getting access to the remains inside?
Yes, if it's secured.
Is that also the type of storage vessel that could make it difficult to determine a time, a PMI?
Correct.
Time of death?
Yeah, postmortem interval, yes.
Okay. Is that something that you typically try to make an evaluation, the PMI postmortem interval during your autopsy evaluation?
Well, I wouldn't say specifically, but it's something we generally write down descriptions of decompositional changes that can be used to opine as to a postmortem interval.
Okay. Would the temperature outside, say the weather conditions, would that impact it?
Yes, I mean, it depends on where the remains are. I mean, where are they stored? How are they stored? Temperature is certainly a big determining factor.
Okay. What about, you testified to this, what about insect activity?
Yes, insect activity, animal activity as well.
All right. Did you see any signs of animal activity on the remains of Melissa Wolfenbarger during your evaluation?
No, I did not see any evidence of animal activity on what I had to examine or on the photographs.
And what would you observe if you'd seen evidence of animal activity?
Okay. Typically think about, like, say, dogs or carnivore type activity, chewing, gnawing on the bones, tearing of flesh, but especially with looking at the bones, looking at gnawing or scratching, and I did not see any of that indicated on the bones.
Okay. Show you what's been marked as State's Exhibit 43. Can you tell us what we're looking at?
That looks like some type of an article of clothing. maybe a sock. I don't know. It looks kind of muddy.
And State's Exhibit 46, what is that?
State's Exhibit 46 is the left foot, again, showing decompositional changes and protruding out of the soft tissue. I see a segment of bone that's broken.
State's Exhibit 47, can you tell us what we're looking at?
State's Exhibit 47, this appears to be part of an upper extremity, so upper arm and forearm.
Should we watch Mrs. Doubtfire for movie night tonight?
And State's Exhibit 48.
State's Exhibit 48, again, this looks like some type of article of clothing, maybe sweatpants that are dirty and appear to be kind of breaking down or degenerating.
Okay. I'm now showing you Exhibit 51. Can you tell us what that is?
Okay, State's Exhibit 51 are the various portions of the extremities with flesh removed from some of these bones, and they're kind of placed out on the table.
Okay. And State's Exhibit 54. You know what that is?
Okay, yes, State's Exhibit 54 is one of the bones showing a series of kind of roughly parallel disruptions of the bone, referred to as tool marks. These appear to be superficial cuts in this bone.
All right. Now, you tell the jury, is it different cutting bone with flesh on it versus cutting a bone that's been defleshed?
Yes, there is.
And what is the distinction, or what differences in those experiences have? Can you tell the jury?
Yes, it's harder to cut through bone, specifically with the types of saws that I use when there's flesh on there, because it just doesn't cut well through soft tissue or flesh. The types of saws that I typically use, the oscillating saws, are very good cutting bone, but not soft tissue.
Okay.
And it tends to catch on the soft tissue.
And when you say tends to catch, what does that mean?
The teeth tend to be somewhat fine, and the tissue gets in there, and it just kind of snags it, and again makes it hard to control and difficult to cut.
All right. Showing you State's Exhibit 56. Can you tell the jury what that is?
Okay, State's Exhibit 56, we're looking at bones from a lower leg. The thin bone that's at the bottom of the screen is the fibula, which is the thin bone that's in the lower leg area. And you can see the superficial cuts on it. And then the bone above it that looks more irregular, that's the tibia, and it is more broken than cut.
And you say superficial cuts.
Whoops.
Are you referring to that portion in the screen depicted now?
Yes, I believe that was in the previous exhibit.
Okay. And State's Exhibit 60. Is that further example or signs of some type of mechanical device coming in contact with the bone of Melissa Wolfenbarger?
Yes, it is. That's an end of a bone that has been cut.
Okay. All right. Now, Dr. Terry, based on your review of the photographs and reports, are you able to make an independent determination as to the cause of death of Melissa Wolfenbarger?
Yes, I can.
And what was the cause of death of Melissa Wolfenbarger?
The cause of death is ruled by Dr. Parker, or my opinion?
Your opinion.
Okay, which I think are kind of subtly different. But my opinion is that the cause of death is undetermined due to dismemberment with concealment of the remains and decomposition. And actually, and also with incomplete recovery of the remains because the torso was not recovered.
All right. What can't you determine based off the things that are missing, the remains that are missing of Ms. Wolfenbarger?
I'm sorry, can you ask me that one more time?
Different way. Did you have enough? Let me ask you this: were you able to tell if Melissa Wolfenbarger was strangled?
No.
Why not?
Because of the decomposition of the remains and the lack of neck structures to examine. That makes determination of whether or not strangulation has occurred very difficult, if not impossible.
Okay. And can you determine whether or not Melissa Wolfenbarger was stabbed to death?
No, cannot.
Why not?
Again, we're missing the torso. Someone could have been stabbed or had other injuries inflicted on the torso that would have been responsible for the death, but you don't know because you don't have that part of the body to examine.
Is that the same difficulty you would have trying to determine if she was shot?
Absolutely, yes.
And is that ultimately why you're saying undetermined?
Yes, because the cause of death is undetermined here because can't say precisely how she died. And it is confounded by the fact that you have incomplete recovery of the remains. They've also been dismembered. There's been concealment of the remains, and there's decomposition.
Okay. Now, what would you say as to the likely cause of Melissa Wolfenbarger's death?
Objection. Speculation.
She's an expert. I'm sorry.
You want to approach for a moment?
Sure.
I knew that was going to be a battle. Hope you can get it figured out. Hi, it's not real. We do have fun. We do have fun. How's everybody doing? I think it'll be fun to watch Mrs. Dotfire.
Timing of death, or is it like? Okay. Now, what would you say as to the likely cause of Melissa Wolfenbarger's death?
Objection. Speculation.
She's an expert. I'm sorry.
She died of natural causes.
And Dr. Terry, is it likely that Melissa Wolfenbarger died of natural causes?
Given the circumstances, I would say that's very unlikely that she died of natural causes.
And if you could articulate why your determination is unlikely that she died of natural causes.
Again, the body's dismembered. There's an attempt to conceal by placing it in plastic bags. I don't have, she was, as far as I know, she was a young female. I have no information about any significant health conditions, but even so, the fact that she's dismembered and concealed is very suspicious for some sort of non-natural death.
Okay. And when you say suspicious for some type of non-natural death, could you be more specific? Are you referring to a homicide?
Yes, I'm saying that it's very suspicious for homicidal violence.
Thank you, June.
That she's dismembered, concealed. That is very suspicious. I can't say exactly how, but it is very suspicious.
All right. And the marks and the cuts, do you have a determination as to whether they're ante or post-mortem?
Yes, I'd have an opinion that it's most likely postmortem.
And why is that?
Well, first of all, we don't see any discoloration of flesh associated with that. Second of all, just in terms of practically speaking, it would be very hard to dismember somebody while they're alive. And especially with the marks that tightly aggregated, you'd need to have somebody incapacitated or very significantly restrained to do that. And again, this is most consistent with something that has occurred post-mortem or after death.
All right. Now, in terms of the manner in which a homicide could have occurred, if say, for instance, Melissa Wolfenbarger was strangled, would you expect to see, like I said, the presence of blood in and around the surrounding remains themselves?
No, would not.
Why is that?
Strangulation typically does not result in the liberation of blood.
Okay, and considering that possible manner of death, as well as the fact that,
I'm sorry, you said manner of death, that's a cause of death when we talk about strangulation. I'm sorry, just want to be precise about that.
Let me ask you this. Did you, when you were doing your evaluation, did you consider the possibility that she was murdered at that location where remains were located?
I mean, that's a consideration, but I don't think it's a particularly good or valid one.
Okay, so your I guess your consideration during the autopsy was that the remains may have been placed there. She may have been murdered somewhere else.
Yes, if she were murdered, it was most likely somewhere else.
And just referencing things that could impact a timing of death or make that determination, would you have been able to tell if the remains had been, say, refrigerated?
Not necessarily, no. I mean, but again, she's been dismembered and she's in plastic bags. The remains could have been anywhere.
And if it had been, say, the remains were refrigerated, how would that have impacted a time of death determination?
That would slow down decomposition, much like if you take any meat and put it in your refrigerator. The refrigerator versus the freezer, it will slow how it degrades.
Okay. One moment, Judge.
Sure.
I'm inviting people to our movie night. We're WM. Hello, you're eating a burrito? What kind of burrito are you eating? Is it bean and cheese? Is it fajito burrito? Chicken or beef fajito? Is it liver and onions and cheese? What kind of burrito are you eating, my dear? What kind of burrito?
Your Honor, can I approach?
Sure.
Oh, delete messages. I'm deleting messages. Wow, that's good, Frankie Leroy. Oh, that's okay. Hi, it's not real. The big thing is you need to validate your account. So there should be a green box with a check mark. You have to click that. And when you click that, that validates your account. And then you have full access. I'm going to start taking some things home, I think, tonight.
Thank you.
All rise for the jury.
We done
were
for the
citing
day?
Williams case, which I found, I think you also cited a
Come on, click, click, click. So if we finish early, I'm going to go home and start getting ready to move my studio. A lot of work. I wish I had more people here to help.
If you would step outside for just a few minutes. Thank you.
Bean, cheese, and potato. Yum, yum, yum. Hash brown or
Okay.
real potato?
So the reason that I asked the jury to step out is that we had, at one point, Mr. McDermott had objected to what he was concerned was going to be a line of questioning by the state regarding this witness's statement as to the results of some sort of DNA. I indicated that for now we were going to stay away from that topic with this witness based on the discussions that we had at the bench. And the reason that we are now revisiting that issue is that Mr. Fawcett approached and asked the court to sort of revisit that ruling. And I felt like we needed to have a more fulsome conversation on the record.
Real quick, Tinkitude, my son, due to life changes, things have changed for us. And unfortunately, he has decided to close his business and go down a different path, which is fine, but it's sad for me. It's very emotional for me. He's been doing this business since he was 19. He's 25. It's been a really good run until recently. I have grown very comfortable in this space. I love this office. I love where we're at, but it's just not something we need to be doing anymore. So I am going to have to move 2,000 square feet offices home into my 1,200 square foot already home that's built. So we're going to have to get storage units. We're going to have to move out by the end of the month. I've got to move all of this whole entire studio home, along with my beading and sewing room, and I got multiple rooms. So it's going to be chaotic. And I actually start my final semester of college for my bachelor's degree this Monday. And I'm doing what's called an 18 hours a semester. 12 is normal. I'm overachieving. And so for me, I am very a little emotional about it, but we're going to move this into my home. And so I have got to, and I physically can't do a lot of lifting and moving. So it's going to be an interesting road trip. So what we've got to do is either this weekend or next weekend. And I'm thinking about doing it next weekend, which will make it the 30th and 31st is to move the studio. Or this weekend. I don't know how we're going to do this, but we got to move the studio home and make sure it's up and running for the Donna Adelson trial. Yeah, a lot of changes
on that topic so that I could rule. And so that's what we're doing now. Mr. McDermott, you were the one who originally asserted that it would be improper for the expert to, for Dr. Terry to make those statements. And you were citing the Williams case, which I found. I think you also cited a Watkins case, which I was not able to locate. I mean, I found, that doesn't mean it, I mean, I just can't find it. I found Disharoon, which obviously where I think Namias is indicating that's an issue that's before the Supreme Court, but.
You said Williams, but the case I cited was Smith v. Arizona.
I apologize. I thought you said the Williams case out of the U.S. Supreme Court and the Watkins case out of the Georgia Supreme Court.
Hey, June, will you go to the verify section in Discord and help Mr. Bean?
Smith v. Arizona,
Please.
out of the U.S. Supreme Court.
That's after Williams and explains Williams.
Thank you. That's the part I was, well, that shows you why I couldn't find the Watkins case.
Smith v. Arizona is 602 U.S. 799.
602 U.S. 799. And what is the?
779.
And what is the Georgia case?
Is Watkins is 320 Georgia 862.
320 Georgia.
862.
Thank you, sir. If you'll give me just a second to pull that up, and then Mr. Fawcett, I was going to call on you to let me know what the state's position is.
If you read Watkins, you can start at 872. Paragraph head note 16. The middle of that paragraph explains it in 2 sentences. Yeah, so. I'm sorry, 320. We're at 862. Looking at around 872.
So can you give me that site again? Because I thought you said 320 Georgia 860, but that's not.
862.
Thank you.
Hey, June, can you go and let me know if you can help Mr. Bean in the verify? I'm lost. I don't know how to do that. Yeah, there should be a green tech. I have no idea. All honestly, I think Miss June is the expert compared to me.
Yes.
I don't know.
Your Honor, the state is relying on 247703. I think the issue comes down to whether or not the state is intending on introducing documents related to those test results. The experts can rely on evidence, information that is not admitted into evidence, even evidence.
And routinely do, informing their opinions.
That's correct. And so her opinion is based on it's going to be called to determine the cause of death of Ms. Wolfenbarger. And ultimately, she relied on the test results from LabCorp to make that determination as to the cause of death. And that's what her opinion is based on here.
I think maybe part of the reason I'm confused is what exactly is the DNA result that that we're talking about here?
So
is it confirming that this is Melissa Wolfenbarger or that there's some sort of DNA match to her?
Yes, confirm. Well, the DNA match from well, actually, no, it's the swabbing of Norma Patton and the comparison of that to the extremities that were located on June 1999. Confirming that she was related to Norma Patton.
Okay, and is that in dispute?
I didn't think it was.
I mean, forgive me if I fully acknowledge I might be missing something here, but I was not aware that there was a dispute that those body parts were in fact Melissa Wolfenbarger's. Maybe there is.
Well, first of all, it shouldn't matter whether there's a dispute or not. The rule's the rule. They can't testify to those.
Well, except that I don't have to venture into deciding what the rule is and how it applies in this case if it's not relevant evidence. That's why I'm asking the question. But yes.
There are test results in the back and forth discussion over identifying those remains that in some cases they did not match. So I don't think it is a 100% proven conclusion that all of those remains pertain to Melissa Wolfenbarger.
Okay. Well,
what?
I guess that demonstrates that I did miss something. There apparently is a dispute that all of those body parts are belong to Melissa Wolfenbarger. And again, asking the obvious, Mr. Fawcett.
So what he's saying is that the defense is disputing that every single one of those body parts actually belong to Melissa. So now the defense is trying to say DNA test every single one and make sure that every little microscopic piece is Melissa's. Oh my God. You know what? He's throwing everything in, including the kitchen sink, the toilet, the duvet, everything at this.
Why would whether those body parts belong to Melissa Wolfenbarger or not be evidence of the fact that her manner of death was homicide?
I guess I'm not understanding the question.
So you,
Thank
I
you,
don't
June.
understand the DA to be offering, I guess the evidence that you're seeking to offer that this witness would testify about is the fact that she understood from the DNA result that those were Melissa Wolfenbarger's body parts.
Correct, yes.
Some of them anyway, according to Mr. McDermott's characterization of whatever that shows. Why does that contribute to the ME's understanding of whether the death was accidental, homicidal, suicidal, or undetermined?
Well, I mean, I think she wouldn't be performing a cause of death determination if the remains weren't first determined to belong to the same person the skull did. And I think the skull is being compared with extremities. And that's a part of that too, because you have the same type of cuts and marks on the bones of the skull as you do for the extremities. I think that's a pretty significant fact in that determination of the cause of death being highly likely of being homicide. So I think that, you know, it wouldn't have been a comparison of the extremities with the skull if it hadn't been that information provided by LabCorp to Dr. Terry and Dr. Parker. And ultimately, that's why they made that cause of death determination after all the parts were identified and matched the parts on April 1999, the parts on June 1999. So ultimately, if there's an issue as to a specific part, the Dr. Terry can testify as to which part she swabbed and sent off. So if there's a femur versus another femur or an arm that's in dispute, I think that goes to the weight, not admissibility.
Mr. McDermott, can you, I've got Watkins pulled up and I'm still admittedly struggling to locate the portion that you're directing me to.
Okay.
One part of the case that we were successful in.
Yeah.
Congratulations. I'd love to read it, but I can't find it.
So first of all, that's the state case. That there's also the Supreme Court case that it's Watkins is citing. But if you go to 872.
You said, I think you directed me to a head note and I can navigate it more quickly from there.
So head note 16.
Thank you, sir.
And that'll take you to a paragraph that begins with the word second. Second, the trial court clearly and obviously erred.
I have found it now. Thank you very much.
The beginning of that paragraph says to begin the Sixth Amendment's confrontation clause.
I just wish he'd give it up.
The Watkins case or the Arizona case that Mr. McDermott is referring to.
I'm still looking at it, Judge, but we can proceed.
Okay. As I said, when we were at sidebar, Mr. McDermott mentioned the Watkins case, but I couldn't locate it while we were up here. I have now had an opportunity to review it, and it does appear that the Watkins case and the Smith versus Arizona case on which it relies would prohibit that witness from testifying. I understand your effort to distinguish it by saying, well, we're not offering the lab result itself in evidence. And I agree with you that expert witnesses do routinely rely on other people's opinions. But I think that the original ruling I made at sidebar is still the ruling, which is that the DNA test result is hearsay. And there's no one here who can testify to its, to the truth of that result. Or at least, well, I take that back. There might be, but this witness is not that person.
All right, Your Honor, I would ask for permission to inquire as to Dr. Terry whether she collected a sample from Norma Patton, what she did with that sample, and then what she did after the sample return. I don't think that line of questioning
Tink, please go to mod chat. Tink to mod chat. Thank you.
it touches on the results themselves. It just explains her actions and activity, and then what she did after she received information back from that.
Mr. McDermott?
I think the rule covers that type of questioning. I mean, it's clearly designed to elicit through dancing around the issue of the statement that's being, the truth of the statement that's in the lab results. And I would say that's just as much a confrontation issue.
Okay. So as I understand it, Dr. Terry did in fact conduct a swab herself. She's certainly allowed to testify about something she undertook. She's also allowed to say that she sent it off for testing because that's something she also did. The extent to which she received a result or anything like that, I agree, invites this sort of cutesy half dodge around the fact that there's not a DNA test result witnessed currently and that DNA test result's not in evidence. And so just in generally speaking, Mr. Fawcett, the two questions you mentioned at first, I totally agree. Those are fair game. Those are actions that this person took and she can testify about them. I think to some extent you could probably ask her what her other steps taken were in her investigation that led to her decision. But what you're going to want to be real cautious about is treading too closely to the line that invites her to say, after doing that, did you develop an understanding or whatever? Because Mr. McDermott's concern is correct that it comes too close to creating an inference that's not supported by any evidence in the trial that there was a positive DNA match.
Yes, sir. I understand.
Mr. McDermott, you can object when he asks the question if you have an objection to the particular question. If you find it objectionable in some manner, other than the record that you've already made. Anything else before we have the jury back in?
No, I thought we were going home. It's 5:15. It's 5:15 their time. I thought we were going home. I thought we were going home. I got a lot to do. Hey, Angela, how are you? Okay, reboot it. Hi, it's not real. Reboot your Discord. Just X out of it and go back in. And then maybe Miss Tink can help you with it because I sure in the heck don't know.
Have the jury back in.
Nothing from the state.
Okay. Mr. McDermott, anything from the defense before I have the jury
She'll
back?
be there.
No, Your Honor.
Okay. Can I have the witness
She'll meet you there in just a minute, boo.
back, please? Thank you.
Jury coming back in? We'll get you in. We'll figure it out.
Compared.
Yes.
Here we go. I think they're going to go till 6. For my time, I hope.
Dr. Terry, did you ever meet with Norma Patton?
Yes, I did.
And you recall around what time period that would have been?
I think it was March 19 of 2003.
Okay. And are you familiar with the process of collecting swabs or samples from individuals?
Yes.
And can you tell the jury whether you did that at the time you met with Ms. Patton?
Yes, I did.
Focus.
And are you familiar with collecting samples from other items that you intend to have compared?
Yes.
And did you do that in this case?
Yes.
And in particular, did you swab the extremities of Melissa Wolfenbarger that were located in this case?
No, the extremities were not swabbed.
Okay, what other item, a piece or body part was compared?
I'd actually have to check the record to see, but tissue from the extremities, bone or soft tissue, had been submitted for DNA.
Okay, all right. And is that the process that you use in your identifications for skulls as well as other parts as well?
It can be. Oftentimes with skulls, though, if we have dental, we will use dental to establish an identification rather than DNA.
Okay. I want to turn your attention back to some of the marks in the we were just testifying to. I'm going to show you States Exhibit 66. Does that look like a saw to you?
Yes, that is a type of saw.
Okay. You familiar with the term, say, sawzall? You with that term?
Yes, sawzall or reciprocating saw.
Okay. You familiar with the motion that type of saw makes?
Yes, I am.
You're using.
Yes, I have.
The marks that you were testifying, Mr. Wolfenbarger, an instrument that can make the type of testifying.
June Tinkitude, I just want to let you know Tracy K's got it. Mr. Bean, please go to verify. She's got you hooked up.
A couple mark, yes.
Based on experience?
Yes, based on my experience.
That's all I have, Judge.
Thank you. Mr. McDermott, questions for this witness?
Yes, ma'am. Not many. Hello, Dr. Terry.
Hello.
You remember me?
Yes, I do.
We met just a couple of weeks ago, I believe it was, or?
Yes, we did.
Okay. And that was at your office?
That is correct.
We discussed several aspects about the case.
Yes, we did.
Okay. What methods again did you use to determine the identity of the skull?
The method that was used to determine the identity of the skull was dental.
And did you mention that you did x-rays?
Yes, x-rays were taken, or I had taken x-rays taken in the medical examiner's office.
Okay.
And that was to establish the dental.
And when you establish the identity through methods such as that, is it important to keep records?
Yes, it is.
Okay. And do you normally keep records when you do something like that?
Yes, records are kept in the medical examiner's office.
And did you preserve the x-rays in this case?
The x-rays should be preserved at the medical examiner's office, the Fulton County Medical Examiner's Office, yes.
And are you aware that no medical or no x-rays exist in this case currently?
I'm not aware of that, but there have been changes in the regimes over the years. And at that point in time, there was the hard copy x-rays and we kept those x-rays there. Now, I have not worked in that office since 2004. So I don't know, but they were there at the time I left the office. And now so many things are digital, but those x-rays were there at the time I left the office.
Whose responsibility was it to preserve the x-rays?
It's, like I said, they're there in the office. They were maintained in the office. So I would imagine it'd be the records custodian for the Fulton County Medical Examiner's Office.
When you did the dental comparison based on the dental charts, not the x-rays, but the charts, do you remember the x-rays that were given to you to start the comparison?
Yes, there were bite wing
I'm sorry. I said x-rays. I meant dental charts.
Oh, the dental chart. I have documented in my note that there is one page of dental charts.
Okay. And do you remember where that came from?
It came from Detective Stott, S-T-O-T, from the Henry County Police Department.
And do you remember the dentist?
I do not recall the dentist.
I wouldn't expect you to know his actual name. Do you remember what date that dental record was from?
It was from 1991.
1981. Melissa would have been 13 years old at that time.
I do not recall her date of birth.
Okay. If well, Do you remember observing the remains of the head? You said the first time you saw it was when?
February of 2000,
Okay.
when I was turning them over to have a reconstruction done.
So you never saw it when it was not a skull?
That is correct. I just saw pictures.
Okay, so you've only seen pictures.
Up until that point, yes.
And in those pictures, you could tell that it's badly decomposed?
Yes.
And you mentioned that there were no flies on it, so that was probably a recent.
Right, that it had recently been exposed. I didn't see any fly eggs. I didn't see any fly eggs described on it. I did not see any maggots or maggots described as being associated with these remains, even though they were described as being badly decomposed.
Okay. And you remember that the other remains are in similar condition?
That is correct.
And they had been in these bags?
Correct, with the exception of the one that was out at the time of the discovery, but a bag was nearby.
And Mr. Fawcett discussed with you the concept of PMI, post-mortem interval, is that correct?
Correct, that is what
And
PMI stands
that's
for.
a fancy medical examiner way of saying how long ago did this die?
Correct.
Do you remember me asking you questions about PMI when we met?
I do.
And do you remember me asking you, based on the pictures of the skull and the remains that we saw, if that could have happened in a relatively short time?
I do remember you asking that, yes.
Okay. And do you remember answering yes?
Yes, that is a possibility, yes.
Okay. Do you remember me asking you specifically, would it have been conceivable to have gotten in that condition within 30 days?
I do remember you asking that, yes.
And your answer was, yeah.
Yes, that's possible, yes.
Well, you didn't say just that's possible.
Oh, okay, well.
You said enthusiastically, yeah.
Well, I mean, again, it's possible. I wasn't having the conversation transcribed, you were recording it, but yes, it is possible.
Okay.
But there are a lot of variability or variables that go into how quickly something decomposes.
Okay. And we discussed those when we met, right? That they were in bags.
Yes, we did.
Those bags could have been exposed to sunlight.
Yes, the temperature, yes.
Temperature is very important to
Temperature.
decomposition.
It is very important to do.
And something in a black plastic bag in the sun would be warmer inside the bag than outside.
That is correct.
Okay.
I think I also mentioned, we don't know where the plastic bags have been too. They could be stored somewhere.
It's fair to say, I'm sorry, did I stop your answer?
Oh, no, I was just going to say, there's just so many variables, it's difficult to say.
Yeah, that's my point to ask. When you normally do post-mortem interval on remains that are found, it's usually an intact person.
That is correct.
And all those variables, you can calculate to some accuracy how long it's been.
Yes, some of those, we can, we have some knowledge of, yes.
But when a body has been dismembered, as in this case,
Dismembered, placed in plastic bags, potentially concealed.
pretty
Yes.
much all that calculation goes out the window.
Correct. There are just too many variables there to say what the postmortem interval is.
And I think you said to me, so it's like, could you say it's been days or weeks? Probably something like that.
Correct.
Okay.
It could be days, weeks, months. Yes.
Thanks, all the questions I have, Your Honor.
Thank you, Mr. Fawcett. Any additional questions for this witness?
Now, you were talking about the different variables. Can you say, based off of the information you have, the photographs and the circumstances, that the remains were found when Melissa Wolfenbarger died? Can you say that?
I'm sorry, can I say?
Can you estimate a time of death?
Oh, no, I cannot estimate a time of death, no.
And in terms of the variables that you were speaking with, would say the tying up of the remains in a bag and dropping them off at that location, can you say that they weren't there or that she didn't die in December, for instance, of 98? Can you say that?
No, I cannot.
And what type of variables prevent you from making that determination?
Again, she's been dismembered, placed in plastic bags. I don't know where these bags have been stored or for how long have they been at the location where they were when they were discovered. Just because they were discovered there doesn't mean that they've been stored there for a period of time. I don't know where they've been between the time of her death and when they're discovered. And I don't know when the time of her death actually occurred. So I don't know.
Okay, that's all I have, Judge.
Thank you, Mr. McDermott. Anything else?
Nothing further from the defense.
Thank you so much, Doctor. You may step down.
Thank you, Your Honor.
She's like, I'm out.
Counsel, can y'all approach?
She's like, I'm out. That was awkward. Oh, sorry, I banged my camera. That was awkward, y'all. I mean, like, seriously awkward. Wow. I don't know what to think about that, y'all. I don't know what to think about that. I'm cringing looking in here, just thinking I'm going to have to take all this home. I don't want to do it. But we have to. I'm going to reframe it, make this a new chapter and a relaunch. I got to do something positive.
Thank you, ladies and gentlemen. So it is about 5:15. We are going to adjourn for the day. I'm going to direct you a couple things just as I have each day. One, I need you to return tomorrow morning at 10:30. Tomorrow morning again, 10:30 a.m. We will begin then. And then I will just advise you, as I have each day, that your decision in this case is supposed to be made only based on the evidence that you hear in this case, in this courtroom, and not based on anything else. And so it would not be proper for you to do any independent research. Don't drive by anywhere. Don't look anything up. Don't look anybody up. It also would proper for you to anyone about this case, or to allow anyone to talk to you about this case. And that includes amongst yourselves until I instruct you to actually begin deliberating. And then the last thing, again, in case there is media about this case, I'm just instructing you to please avoid media. Don't watch the news. That way you understand that you'll be complying with your obligation.
That's on them, not me.
Only make your decision based on the evidence you hear in the court. Thank you all again for your patience and attention to this process. I will see you tomorrow at 10.
I don't know how to file.
Well, somebody in your office certainly does. Right. Have witness attack. It happened either.
Oh my
I
God.
was certainly agree.
We got drama. I know. Thank you, Tinkitude. It's going to be a nightmare. Maybe we're not going to be dark furniture. We're going to be white.
Let me
Everything's light.
make it easier so you're not.
But I like the warmth.
That's why I asked you to look at them. So
Are you
let me
sick?
put them on the screen. It'll help. It will also let you understand how they will be displayed to the screen when I do the charge. So anyway, the second charge is just a general pattern charge. I mean, it's not a pattern, just a general charge of, hey, the law
is what I say it is, and other than typographical errors, pattern charges. The only issue to this evidence in this case.
I can give you a list of my issues. 131.40 witness supported. I'm not sure we have that.
Yeah. So again, I exercised no editorial control over this. I simply put on here what you guys had listed. So not have we not had that, but generally speaking, attacking a witness under 131.41 is a very specific process that may or may not have happened either. We certainly have not had any witness supported. I'm not even sure we've had witness attacked, except perhaps by, that one needs to be taken perhaps by prior convictions.
And then,
hang on. What are your thoughts in terms of witness supported, Ms. Hilton, the conversation we were just having?
Yes, Your Honor, we agree.
I mean, I haven't heard anyone be rehabilitated in that manner.
Correct. We will draw 131.
And to be honest, I don't know that he actually asked for that. It's one of those, they go together. And if we have witness attacked in that particular one, I'm going to keep witness supported in that unless somebody agrees it shouldn't. Mr. Samuel?
I
I made a note of 13180 in case anybody was wondering what we were referring to. I was referring to the immunity of Norma Patton.
Right. You made that note in, did you have a chance to file? I know you gave them to me, and at the time you gave it to me, you said you had not yet filed the jury charge request.
I served it. No, I didn't. I don't know how to file.
Well, somebody in your office certainly does, Mr. Samuel. So
yes, someone can do. Yes.
Okay.
But everybody's got it. You know what to do about 404B and all the 13410. I'm perplexed. I'm beginning to think you're just not going to give any 404B instruction at all because there was no similar transaction evidence in this case.
That is you. I think you're beginning to suspect correctly.
Yeah.
As I was looking at, I always wondered because I heard what I would really categorize as 404B and your objection and your belief that they are these prior alleged the testimony that the state has offered about prior incidents that they would characterize as abusive in support of Dr. James or Ms. James's testimony. I believe, as I said at sidebar and then said again when I declined to give a limiting instruction, I believe that those are intrinsic and that intrinsic evidence is allowable. The jury can consider it for purpose, and so there's no basis for elimination.
Right. To be candid, I can't even figure out what the structure would be, which is kind of my whole issue is what was it? Unless we accept your position that it's just all part of the crime. I'm not sure what the 404B instruction would even be, which is why I thought the evidence should be excluded. But we know where we've been on that.
Sure. Yeah. And I think you have, I think I have, after I had that discussion with y'all at sidebar, I think I actually went in and deleted those limiting instructions and the associated other crimes, wrongs, and acts instructions.
I don't want to waive my issues, but I certainly understand that they're not appropriate if, in fact, they weren't admitted as similar transactions. Okay.
Yes, sir.
I think prior difficulties, 13420 still stays in now.
Any objection?
No objection to 13420.
It needs some editing, but
Well, yeah, I mean, if there are parentheticals still in there, that means I haven't tailored them yet, but I'm not going to waste time tailoring stuff if everybody says, no, we don't need it. So,
right.
Can we go back to 13180, the immunity or leniency?
Yes.
Your Honor, they would object to that being given. While Ms. Patton did discuss the immunity she received, that was as related to her trial with Mr.
Patton.
Mr. Carl Patton is not anything doing with this current case. She hasn't been given immunity. She hasn't been charged with anything in this particular case or matter before this jury. There's no pending prosecution before this jury. There's no negotiated pleas. She wasn't a co-defendant in this case, so there's no grants of immunity or leniency for similar matters as it relates to this case. So we would object to 13180.
Mr. Samuel?
Usually I do charges sitting down, but I'll stand up.
That's fine. You're not bothering me.
Once you're given immunity, you're given immunity. It carries forward, all the.
Oh, hell no. I'd make his butt stand. Now, you ain't bother me. Boo, stand up. This is a court of law. I could care less. It is 5:34 in the afternoon, and you're ancient, and you got one foot in the grave. You're going to respect the court, and you're going to stand up. Man, she's too damn nice. I'd make him stand.
Federal cases, and all of which are, the names of which are escape me now, but the New York case. Anyways, the U.S. Supreme Court said once you're granted immunity, it's good for life on that grant of immunity. So theoretically, which is all that really matters for this, she could still be prosecuted, and because the statute of limitations hasn't run, because it never does in a murder case, she could be prosecuted in theory in whatever it is, Henry County, Fayette County, wherever. And so having testified here, because she was immunized, she doesn't have to worry about that. If she hadn't been immunized and she got on the stand here today, yesterday, whatever day it was, and said, yes, I participated in the murder of some of the people my husband killed, she could be prosecuted for it, but she can't because she's immunized.
So my concern is not quite, I think right now I sort of agree with Mr. Samuel, but not for the reason that he's outlining. It's more that my understanding of the law around it and the pattern charge certainly is that it's not specific. right? It doesn't say they were granted immunity in this case. And so if it's intended to be, I mean, because the factors we take into consideration when we're assessing the credibility of a witness are pretty broad. These are just examples that we give a jury in terms of things they can consider. If the state wants me to think about not giving that charge based on Mr. Samuel's request that I give it, I would say, see if there's case law that talks about it being specifically designed for immunity in a case, as you outlined correctly, Ms. Hilton, that Ms. Patton was never in any jeopardy associated with this case, and I'll consider that tomorrow.
The
Okay.
case is Murphy versus Waterfront Commission of New York Harbor, 378 U.S. 52.
378 U.S. 52.
Yeah, and there's a long discussion of it in a Supreme Court case decided 6 weeks ago, Coleman versus the state.
K or C?
With a C, S25 AO 191. Different circumstances, but it talks about how broad immunity really is. Once you've been given it, you're protected for life in every court for that testimony.
Okay. And as I said, that may go directly to my point that this pattern charge is not specific about this case. It's just about immunity generally. And if that's the case, then I will give it based on your request, but I would like some more information about that topic. So I'll take a look at this case and hear from the state tomorrow on that issue.
Your Honor, before you go, I'd just like to cite a case from Georgia, Lee versus State, 281 GA 776. And I believe the proposition is that the general credibility instruction adequately covers that.
Adequately covers the other immunity?
The other instruction.
Okay.
I need to drill down on it exactly,
Sure.
but that's what it's saying in the notes on the jury charges.
Okay.
So I'm going to look at it as well. I just wanted to give that to the court.
Thank you. I appreciate that, Mr. Wilson. Okay. Anything else, Mr. Samuel?
Yeah, a few more, but they're not big. 13430. It really just needs to get rid of all the parentheses for the defendant. No felonies of Mr. Wolfenbarger's work, but all the witnesses.
Yeah, the reason, that's why I haven't tailored it because
At first I crossed it out, but then I realized, wait a second.
yeah, there's lots of witnesses we've heard felony convictions about. And so if evidence comes in about felony convictions of the defendant, right, then I'm not saying it has, I'm saying if it does, then I would tailor it to be, you've heard evidence about both the defendant and a witness's criminal history. But if it's just witnesses, I'll say that.
Right. I'm a little in doubt about 13510 identification. The first page of it, I think is fine. You got to prove that the defendant did it. That have identified him as being, but this is
all about whether you can trust eyewitness identification, et cetera.
Which we really didn't. I mean, it's not an issue in this case. We don't have any eyewitnesses identifying anything. So I just thought we should get rid of that and 13511, those 2 pages, but leave the first one because that just says someone's got to identify the defendant as the perpetrator. It doesn't necessarily have to be in court, but
Right, I believe we may agree, but if I could just have a moment.
Sure.
Tonight to.
That's fine.
Get it, but
Yeah,
we may be in agreement about.
Okay, let me know. Like I said, I think to Mr. Samuel's point that second part, the some but not all of the factors, if you read those factors, they really do go to a stranger's identification based on eyewitness observation. And that's not really what this case is about. I'm not sure I necessarily agree with your assessment of 13511. That would be more directly here in terms of the state's obligation to identify a defendant, but we'll go, I'll let the state have a chance to look at that and consider it and tell me tomorrow.
I crossed out my crossing out.
Okay.
That was still in.
Okay. Anything else, Mr. Samuel?
Got 2, 3 more.
Sure.
I'm not sure about the motive instruction. I think they have to have evidence introduced of the motive. I know motive is in the malice murder instruction already. That motive is not an element, but may help you decide. But I don't feel strongly. I know it's a pattern instruction. I just don't know that there's evidence of motive that's been introduced exactly.
It seems to,
Except that the pattern says they don't have to prove motive to prove murder. And it also says any evidence of motive. If you want to argue there isn't any evidence of motive that's been offered, you can argue that. And they'll say, but yes, there has been. It doesn't matter. As I understand it, that one is written broadly enough that both sides can argue, here's our evidence of motive, even though we don't have to give it to you. And you can argue there isn't any.
there was I got a typo in causation in felony murder 21030.
Yes, sir.
But 22023.1, which was ours, I'm not quite sure what to do about that.
I'm sorry, what is the typo?
2.20.23.1.
No, I'm sorry. What was the typo in the causation charge?
It says felony murder if you believe that they instead of he.
Ah, thank you.
2.20.23.1. I just don't know how we're going to address this, but we need to probably think about it.
If I had the screaming goat, I would be using it right now, and I'm tempted to go code red because he is just it's the way I feel with him right
Everybody
now.
needs to think about how we're going to talk about the aggravated assault that makes it aggravated.
Yeah, I full disclosure, when I was drafting these charges, realized that I've tried a number of felony murder cases. I've actually not tried a felony murder case before this one where the underlying felony wasn't also charged. I don't know, as my understanding is, it's not required to be, but I've just not had one where it wasn't also charged.
Well, they actually didn't even request ag assault in their pattern.
I understand.
Which Joel and I spent a lot of time thinking about why they didn't do that. But at any rate, we did. But now the question is, how do you do it?
Well, I think we all obviously need to have a more detailed conversation about it tomorrow after everybody's had a chance to look at it. But the aggravated assault charge I think is less confusing. The issue is deadly or offensive. I don't think that I can meaningfully charge the jury on felony murder if I don't tell them, but the felony is based on an underlying alleged aggravated assault. So I think I have to tell the jury, as felony murder says, the underlying felony that's alleged is whatever, and I will define it for you shortly. So I have to tell them what aggravated assault means, but that typically requires the court to explain what type of weapon did it, because that's one of the elements, is that you assaulted another person with an offensive weapon, and then you have to explain what was offensive about it.
Murder, felony murder.
And just to anticipate what we may be talking about tomorrow, it can't be strangulation because that's a separate crime, which is not alleged.
Is the aggravated assault
It's only offensive weapon, not
charged as an offensive weapon in the indictment?
Yes.
Okay.
What indictment?
Okay, anything else?
Nothing. That's all I had on my list.
Okay. I'll just note, in case y'all didn't, it sounds like you would have looked at it, but I do another one that is non-pattern that I typically include. I cannot believe there's not a pattern on multi-count indictments. But this is the one that a lot of us use, and so I include it. You'll also probably note that my charge is sort of in the order of, this is how you consider evidence, and this is, what's been presented to you and how you should think about it. Here are the elements of the crime that you're supposed to be determining if you believe occurred, and then here's how you deliberate.
Nope.
That's sort of the way it's broken up, and so you'll note it's not in number order, but that's sort of how I present it. And also, I sent y'all a verdict form the other day. It's pretty straightforward. It just says we find the defendant guilty or not guilty on count 1, guilty or not guilty on count 2. Any objections to that verdict form?
Wouldn't it be great if this thing was all done by Friday morning and Donna Adelson starts and we don't have 2 trials at one time? Yay! That would be freaking awesome, or at least in verdict watch.
Nothing from the defense.
Okay. So I think it sounds like what I'll do is I will tailor some of the ones that it seems like we're in agreement are going to stay in based on the evidence as it currently exists. Obviously, they can be tailored again, depending on, I sometimes will tailor the defendant's choice not to testify, depending on whether he testifies or not. Although I think the pattern is written generically enough that it can stay in either way. And then obviously, depending on any additional evidence that comes in regarding criminal history, I can tailor those. Beyond that, what I'll do is wait until tomorrow, specifically so we can talk about the aggravated assault and offensive weapon charge.
No promises, y'all.
And then the other ones, the other few that we've discussed.
Can you ask
The
about
immunity charge, yes, sir.
tomorrow- I'm sorry. Can you ask us about tomorrow's schedule? It's 10:30 because you have something else we need to clean up? Do you have another calendar?
Yes, I have the presiding bond calendar tomorrow morning.
So we need to clear out.
Yes, sir.
Okay.
I'm sorry.
We'll put everything in the back. And assuming our case takes a couple hours, I don't know if they have rebuttals. Do you envision going into closing argument tomorrow, or we're into Friday morning for that?
If what were to happen is that the state were to stand up and rest in the morning, and then you put on a case that is relatively straightforward and short, even assuming rebuttal, the state, we probably would be done still in the afternoon. I'm saying pushing 3:00 is my guess, at which point I'd rather get a final on the charge and start fresh on Friday morning with, we all agree that we've got the charge final. And so you guys get ready to do your closing. And then I think that time would be better spent tomorrow afternoon. So no, that's a very long way of answering your question, Mr. Samuel. No, I do not expect to go into closing arguments tomorrow afternoon. Anything else?
No, Your Honor, nothing in the state.
May I have just a second, please?
Yes, sir.
She's like, bitch, please. He's like, bitch, please.
One of my witnesses that we expected we may possibly be testifying today. So I had all my witnesses come.
Yes, sir.
And one of them who's supposed to come didn't come.
Okay.
And I think she's a little bit of an adverse witness.
Yes, sir.
So I'm wondering if we could make arrangements possibly for tomorrow to have a deputy pick her up.
Is it someone, I don't have any objection to that. What are the states? Are y'all aware of who this is?
When do you want to know?
I'm so sorry, Your Honor. We were talking about the aggravated assault.
That's okay. Mr. McDermott was saying he had a witness that was supposed to be here today who did not appear, and he thought that she might be somewhat reluctant or adverse. And he was requesting the court to see about having a deputy assist her in appearing tomorrow.
Oh. No objection from the state?
If you have an order.
I was going to say, if I could touch base with you in the morning.
Sure.
I'll talk to her again tonight, hopefully, and we'll see where
Okay.
it's at.
The only thing I'll ask is if you do want me to do that, you need to have a proposed order ready for me to sign that I may need to change it. So you can just email it to me in Word format. But that way I have something done and you don't have to wait for me to write an order. So, okay.
Staff have a form order for that, or can I make one?
They probably do, but I don't have one at the ready. So
All right.
anything else from the defense?
Nothing from the defense.
Okay. We are adjourned until tomorrow morning at 10:30.
Okay, it looks like they have a witness that doesn't really want to show up. And guess what? The deputy sheriff will go and pick them up. This will be probably the best day of trial tomorrow. Yay. And they start at 9:30 my time. Yay. I'm looking forward to that. 9:30 my time, both start. So we will, that will be awesome. Okay, guys, you know what time it is. You know what time it is. Good luck to the winner. We did it. So wonderful. Congratulations to the winners, which is G14. And oh, I cleared it out. Yeah, having a deputy pick you up. Ooh, doggy, that ain't gonna be good. So anyway, I'm gonna head home so we can start our movie at 6:45. I'm gonna get comfy, get my iPad and set it up and relax because I only had maybe an hour sleep last night. So we're gonna sleep tonight. And so Miss June's gonna be the host because if I fall asleep, I won't respond. So anyway, yes, Weird Debbie, congratulations. Thank you so much. And G14. But also we will finish the Donna Adelson testimony during break tomorrow. We'll be live at 9:30 and y'all come join us. We have fun. We got a new emoji in the YouTube, so go check it out. We got new emojis in Discord. Go check them out. And we will see you tomorrow morning at 9:30. Miguel. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.